Now in session for the regularly scheduled meeting of January 3rd, 2019. My name is Emily Lamb, and I will be presenting the cases today for the board to consider in today's public hearing. Members of the public, at this time, please take a moment to silence your cell phones or other devices so that we can make sure there are no disruptions as the board hears the different cases. For these public hearings, the board reviews the correspondence submitted in support of and opposition to these cases. The board also reviews correspondence and recommendations from other government agencies in preparation for the hearings. In today's hearing, staff will present the site plans, maps, photographs, and other documents that comprise the case record. At the conclusion of the staff presentation, the appellant will present his or her case to the board. After the appellant's presentation, the board will hear those wishing to speak in support of the appeal. If the appeal has opposition, the board will then hear any parties who are here in opposition to the appeal. After the opposition presents its testimony, the appellant will have a period for rebuttal. According to the BZA rules, the appellant has 5 minutes for presentation if no opposition is present. In contested cases, the BZA rules allow 10 minutes for each side to present testimony. Should the appellant wish to provide rebuttal testimony, the appellant should reserve some portion of their allotted 10 minutes. At the conclusion of each hearing, the board will deliberate and then vote on that case. The board is vested with the power to act on these cases under the provisions of the Metro Zoning Code, Section 174180. All section numbers that we refer to come from the Metro Zoning Code, which applies to the entire jurisdiction of the metropolitan government. The Zoning Code was adopted by the Metro Council and became effective on January 1st, 1998. I will introduce the entire Zoning Code and make it part of today's record. The Metro Code requires a record of these proceedings. Because the BZA meetings are recorded for the Metro Nashville network, it is imperative that anyone addressing the board please come forward, sit at the front table, and speak into the microphone. All speakers should identify themselves by name and address and then make your desired presentation. The Metro Code requires 4 members of our 7-member board to establish a quorum. The code also requires at least 4 affirmative votes to grant an appeal. In the event that 5 or more members are present but the appeal fails to receive 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days of the public hearing shall be deemed denied by operation of law. Pursuant to board rules, an aggrieved party may appeal board decisions to Chancery or Circuit Court within 60 days of the hearing date. Additionally, as per the BZA rules, an aggrieved party may file a motion for rehearing by the BZA within 60 days of the original hearing date. After that time elapses, the board's decisions are deemed final and no further action can be taken. If your appeal is granted, you are required to come obtain the permit for which you applied. A permit must be obtained within 2 years for the board approval to remain valid. It should also be noted that if false or misleading testimony is presented to the board, any board approval could be revoked at a later date by means of a show cause hearing before the BZA. Mr. Chairman, I submit that all cases have been filed in proper order, all appellants have been notified by certified mail, and all legal notice requirements have been fulfilled. I do have some preliminary announcements regarding deferrals and withdrawals at this time. 4 cases have been deferred to the January 17th meeting. Case number 2018-619, 2018-677, 2018-700, and 2018-660. All 4 of those have been deferred to January 17th. Additionally, case 2018-704 has been withdrawn by the appellant.
What was the last one?
700 and 660 were the last. Those were the last 2 that were deferred.
704 is the last case on our agenda, and it lists withdrawn. Okay. The very end. Okay. So before we get started, Happy New Year, everybody. We're glad that a start to a new year and a new number of cases. I have to ask John Michael, because he did most of these cases last year. How many cases did we hear last year? 700 and so. I mean, in the old days, when I joined the BZA, what, we have about 100 cases a year? 120? Yeah, man. That's what you call the IT city. So, Ms. Lamb, let's get us started.
For members of the public, our board utilizes a consent agenda at each of its meetings. One board member reviews the record for each case prior to the hearing and identifies those cases which meet the criteria for the requested action by the appellant. If the reviewing board member determines that testimony in the case would not alter the material facts in any substantial way, then the case is recommended to the board for approval. We'll enter into the record those cases that have been so recommended, and if anyone is here in opposition to one of the cases that is identified for the consent agenda, please make sure that, raise your hand, make sure I see that you're here so we can pull it off of the consent agenda yet.
Quick question, can you repeat the names of the ones that were referred to the
2018, 619, 677, 700, and 660. So, Mr. Chairman, these are the cases that have been recommended for the consent agenda. There are just two today. Case 656 involving property at 3509B Renwood Drive. It's requesting a 6-inch variance to allow an existing garage. Is there anyone here in opposition? Yes. Okay, that 6-inch variance request will be heard in its regular order. Case 663 involving property at 520 Raymond Street, requesting a special exception. You're here in opposition to the special exception for the church? Okay, that one will also be heard in its regular order, Mr. Chairman. So we do not have a consent agenda today. So we'll hear all the cases in their regular order.
Okay, I think we have at least one elected official here.
The one that I saw, Councilman Davis.
Councilman Davis.
Would you like to speak now?
I know because January 1st was on a Tuesday, you didn't have a council meeting, so it's tonight. So you got to be with us. You got to go to your normal council meeting. You have a long day, so come here and let us know what you're going on in District 5, and if you want to stay later, that's fine with us too.
Well, I'm going to have to stay later because I have a lot of constituents that live in the neighborhood that have cases in front of you today. And as always, I have to be consistent. And so I'm asking for, for my regular citizens and for the businesses to waive the sidewalk fees and the sidewalk requirements because there's already sidewalks here. I think we have one on the consent that we'd like to take off the consent and present the case in front of the board members, and I'm sorry to increase your day longer because I know
What case was that?
2019-0616. I'm sorry, 2019-016.
01.
Vernon Kesey.
Oh, it's not on consent.
Okay.
So we'll just hear it.
Okay.
Yeah, we got rid of our consent agenda. There's opposition for the two cases that we recommended, so we're going to hear everything in its proper order.
I will see you wonderful people later.
Okay? Thank you. Like I said, you got maybe 3 or 4 hours of us, 3 or 4 hours of council meeting tonight. That's a lot of work. So, Ms. Lamb, get us started.
I don't think I saw any other council members present for the meeting today, so absent any other announcements, we'll go
Future
ahead.
council members, this is an election year. Get your 25 signatures. You too can be on the council.
So absent any other announcements, we'll go ahead and get started.
Okay?
And actually, the first case for consideration by the board, this was one that was heard, 2018-680 is the case number. This was heard back on December 6th, and the appeal failed to obtain 4 affirmative votes. Ms. Sanford, you were not present at that meeting. Have you had an opportunity to watch the video of that hearing?
Yes, I watched it.
All right. That being the case, then, Mr. Chairman, it would be appropriate at this time for us to solicit a vote on this case to determine if we can receive 4 affirmative votes.
Okay, do we remember this case, and should we have another motion, Ms. Lamb, or should we just vote?
We would need, I think we would need another motion.
Mr. Taylor made a motion. And,
Okay. I
I just
Mr. Taylor,
watched
would
it.
you like to renew your motion on this case, or you?
I can
Okay.
tell you what it was.
Can you
that
briefly, Ms. Lamb, tell us what this case was in reference to refresh our memory?
He moved that we grant the variance based on the requirement that the appellant build an opaque fence for the entire length of their property next to their neighbor.
And Mr. Chairman, the request on this property, this shows you the zoning is R20. Just to give you all a brief refresher, zoning is RM20 rather. This is the aerial photograph showing you the property. This is the site plan. Photographs showing you the current conditions of the home. The variances request is from the front setback requirements to construct attached townhomes.
Okay. Alma, would you like to renew that motion to approve?
Yes, I would renew Mr. Taylor's motion, and I will vote yes on that motion.
Okay. Motion's been made. Is there a second? The motion has been seconded by Mr. Taylor. Any discussion about this case? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. Okay, very good. Next case.
The next case for consideration by the board is case 2018-522 regarding property at 1704 Carvel Avenue, requesting a variance to allow front-loading garage. Is the appellant here? Yes, okay. The zoning map here shows you the zoning of the property is R6A. Aerial photography here shows you the property, giving you a sense of the surrounding area. Here you will see the site plan for the proposed construction intended at this location. And finally, photographs of the property showing you its current condition, as well as across the street and up and down the street. Is there anyone here in opposition to case 522? All right, seeing no opposition then, I believe the MC2 Group, Inc. is the appellant. And that you will now have 5 minutes to make your desired presentation. Please be sure to introduce yourself by name and address before addressing the board.
Kevin Kane, 639 East Main Street in Hendersonville.
Rob Cushman, 1019 Avery Trace Circle in Hendersonville as well. This is I believe, our third meeting with you all just to check in on this property. I think there may be a couple extra slides. Is that the case or no? Yeah, they have them in front. Okay. What we were asked to do was to bring back some preliminary
renderings. We have renderings.
Perfect.
Yes.
The renderings, what the street view would look like if we were to do something. Also included in that packet, just a photograph, trying to give you an idea of the topography. I think you've got one with a vehicle parked in front of the lot, just to kind of get an idea where the street level is and where the back of the property is. One of our hardships is the sewer line. The sewer main is in the rear of that property. So when you look at the topography, the elevation change in that lot, the sewer main is in the rear of the property. So being able to get everything, I guess, to the rear of the property, we've got to have the houses sit up quite a ways from Carvel. So
Have you talked to your councilman about this? So originally he said deny. Now it's a little bit less than sometimes he says strongly deny, but you just got the deny.
So the frustration is in conversation, we've gotten I will not oppose you, just kind of the answer of, hey, I'm in the middle somewhere and not strongly one way or the other.
Okay.
He did say, again, in conversation, I want to be consistent and will not support.
Because
Obviously,
Councilman Sledge was the council person when this zoning passed, correct?
he is. That's correct.
Okay.
It's been consistent as far as the councilman right through, so that is correct. And so, verbally, I know in your packet, because I was looking just to see what we had in the packet, that it does say in there that there was a deny. I did send an email just trying to follow up with some of our hardships and with no response, just on trying to say, hey, these are all the things that we're willing to do for the community. We're replacing the water main down the entire street. We are willing to put the sidewalks in, widen the street, do a few of the things for the community that would benefit the community. Just haven't had a lot of feedback from that since.
Okay. And no other kind of new opposition, or have you talked to many of your neighbors about this? And
The only neighbor that's remaining on the street is the gentleman that wrote an email in support. He's the property owner just to the south of this. He's the only one that owns a substantial portion of the street. Sure. Everybody else is a new construction.
Okay.
And directly across the street from you, that's a school?
Yes, sir.
Okay. So you don't have residences across the street that are going to be looking at your front-facing garages?
Correct.
That's the old Central High School for you old timers out there.
And, I remember, the topography, I know it says that you gave us a site, a rendering, preliminary front elevations, and how preliminary are those versus, the thing I do appreciate about them is that the garages are at the street level. You dig into the street, and that they are, at least in this drawing, are dark in a sense that it takes away visual.
They don't stand right out at you. It's not like bam, garage.
They don't jump out. They really are subservient to the house,
And I like your landscaping around it, too.
Sure.
Yeah, and that was per your guidance at the last meeting, and we do have architecture. Those are based around architecture that's completed if we were able to get approval.
okay.
And even the window above the garage door itself kind of blends in with the rest of the kind of look and scale of the house. I like that.
Yeah, and I think it's consistent with what you're seeing going up in the neighborhood as well at the same time.
Any other questions for the applicant? Okay, do you have anything else to add? Okay, thank you. We're going to close the public hearing. Discussion. Mr. Taylor.
Well, we've heard this case several times, and they've come back and I think done everything that we've asked. And, my initial kind of frustration with the situation is that, I think when someone is coming to ask for this type of variance, it's really their burden to show that they've exhausted just about every other option. And I think that they have done a really good job of showing that in the last through the last times that we've had them here. I do think they responded well to the advice that if we were to support it, we would like to see garages at street level and pretty much exactly like they said. So I'm not generally in favor of giving this type of variance, but because of the nature of this street, because of the case that we heard months ago, 2 doors down, where we thought it was going to be the last R6A front-loaded garage on the street, because it's a narrow street, because the street faces a school and not other residences. Because the topography of the particular lot is quite steep.
This is a very unique case. People shouldn't think
yeah.
that they should just be able to build like this in this district. I think for all the reasons that you said, and they're narrow on the street, the school across the street, it's not developed very much.
And the fact that the applicant's willing to put in substantial infrastructure improvements that are necessary for this development, but also positively impact everybody else on the street. I'm inclined to support that.
Is that a motion?
Yeah, I'll move that we approve the front-loaded garage as presented in the preliminary front elevation drawing, specifically that had the garages at street level and
And the reason that we're doing it
subservient to the house. The reason
narrow
is that,
street.
the physical improvements that they're making to the street, the steep topography of this particular lot, the fact that this is one of the last streets that still has front-loaded garages, and that there are not residential neighbors directly across the street. For all of those reasons,
Okay.
I think that they've met the hardship burden.
Very good. Motion's been made. Is there a second? Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. Good luck. Thank you for coming back so many times.
Hey, and really appreciate all your work on it. You worked hard, I know.
Yes. Okay. Ms. Lamb, what's next?
Next case is case 2018-645, involving property located at 935 East Trinity Lane. As you'll see on this zoning map, the zoning here is IR. Aerial photography showing you the surrounding areas. This is the site plan showing the proposed construction on this property. And then finally, photograph showing you the property, the face of the property, as well as across the street, up and down the street. This is a variance from the sidewalk requirements, a request for the variance from the sidewalk requirements. Robert Butler is here. I believe he's the appellant here on this property. You'll have 5 minutes to make your presentation. Briefly, for the board, just a quick explanation. The sidewalk ordinance was triggered in this particular property because it is a renovation. The sidewalk ordinance, this is not one y'all have seen quite as often. The sidewalk ordinance states that if the value of renovations over the course of 5 years, if the value of that is more than 50% of the assessed value of the structures on the property, so the aggregate value of those renovations over the course of 5 years is more than 50% of the value of the assessed structures, the sidewalks are required, and that is the situation in this case, which is why they're here, even though it's a renovation. So I will let you have, is there anyone here in opposition to this case? All right, so you'll have 5 minutes to make your presentation. Please identify yourself by name and address.
My name is Robert Butler.
Please press the button in the bottom.
My name is Robert Butler. The address is 935 East Trinity Lane.
You don't have to hold it down.
Oh, it's on. Okay, cool. We did this renovation about 3 years ago, renovated the interior of this building, and improved the site at that time, what the city required us to do. They required us to have a bunch of parking added to the Ambrose side.
Okay, so when you spent it 3 years ago, how much money did you spend 3 years ago? Or what percentage of money did you spend 3 years ago compared to what you spent in the last 2 years? Or last
3 years ago, I think we spent approximately $350,000 renovating.
And so in the last 6 months, what have you spent?
Nothing.
What do you
The last
plan to
6 months.
spend?
We have a tenant that is moving into half the building. Since our renovation, it's been empty.
Okay.
We finally secured
So this is
a,
like the build-out part.
yeah, it's an interior build-out. We have basic kind of utilities in there,
And
but
so
it's a blank shell.
how much will the build-out cost?
I don't know. I think it's around $100,000
Okay.
that the tenant, and it's 3,500 square foot space on
So
one side of the
that
building.
cost, and then what you did 3 years ago is triggering
It's
the
triggering
sidewalk.
us to go back and redo the site work and the sidewalks that we did to bring the building
How
up to
many
code.
tenants there will be in the building? Is it two-tenant building?
There's about 4 tenants in there right now.
Oh, they're already in there,
Yeah,
and
there's
they've
one.
done the build-out and everything.
Yeah, the initial tenant was myself.
Is there another empty space that you would potentially be completing?
This
Or
would
is this
be, there's a smaller space in the back, but this is the last significant space.
Okay. So what we're looking at is you spent basically $300,000 getting this building kind of ready to what it looks like today, and then the last part was just this build-out. And so you've triggered, because it goes back 5 years.
Yeah, it's
I'm not-
retroactively
Not sure
enforced.
why the
Yeah.
Metro Council, not us, decided to claw back all the way 5 years to trigger the sidewalk, but that's what the law says, and that's why you're here.
Mm-hmm.
So what are you asking for us today, and why?
So the Ambrose side, the city required us, in order for us to pull our original permits to renovate the building, to add a bunch of parking and also a handicap spot on the corner of Ambrose and Trinity. If we were to do the new sidewalks, and it would encroach on that, we'd lose 6 parking spots and our handicap spot.
How many parking spots do you have total?
We have, I have to look that up. I think we have about 30 parking spots.
So you'd lose about 20% of your parking if you
Yeah.
did it?
Yeah, the planning commission recommended that you basically keep everything that's there in good condition, and that you pay the in lieu fee on the Trinity Lane frontage. So they
Yeah.
were, I don't see anything in the planning recommendation that says they would want you to build a sidewalk that would cost you parking.
Exactly. So bringing it up to speed to where we're at right now, everything in the planning commission I agree with, other than one thing. We did already sign over the right-of-way for the Trinity side, and we've recorded that deed. What I'm asking is that if the inspectors come out and do deem that the sidewalk on the Trinity side is not ADA compliant, that we don't pay into the in lieu of fund, and that we do it ourselves. That's basically what we're asking. And then everything else I agree with in the planning commission's
So
recommendation.
you agree to paying on that one side, to pay into the in lieu fund?
I'm asking not to pay into the in lieu fund,
Okay.
but if, because there is a sidewalk there, a 5-foot sidewalk.
But it looks like if this is one of the, that doesn't look 88. I'm no
And that's
architect.
why I'm here, because I
But
know
that's
that there's
not
a section of that.
Looking ADA compliant to me.
Exactly. So that grass area there, when we originally had the building, was parking, and it was blacktop, and the city made us remove that and keep that sidewalk there. But because of that, a lot of that is a curb that quite possibly won't be ADA compliant when the inspector comes out.
Yep.
So what I'm asking is, instead of pay into the in lieu of fund,
That you pay to fix that and
That
make it
I
ADA
actually-
compliant. Okay.
pay the cost and replace the sidewalks on Trinity if it is deemed not ADA compliable, because I want to make sure that my money does go into the exact sidewalks in front of my building rather than into the fund.
There's someone else's sidewalks. So we have the duly elected council member from the 5th District who has joined us at the table. So, Councilman, what do you think about this case?
Well, originally, 5 years ago, I was a council member, and we did make them do some extensive sidewalk. And also, they did do a huge renovation, and I'm asking that, that we waive the in lieu fee. And if the code the inspector says that, hey, they need to do a ramp to make it ADA compliant, let them bear the burden of doing the ramp. And I don't want them to lose the additional parking and the handicap space either, because, it's kind of weird, where we'll replace the whole sidewalks and add the ramp and lose a handicap space and some additional parking, when we could simply just do a handicap ramp and keep the extra handicap parking space and the additional parking.
Okay, board members, questions for the applicant or the councilman? No? Anything else to add? Okay, we'll close the public hearing. Discussion. So I think this case is a little bit different than some of the others. Obviously, we're here to kind of hear a repeal of the sidewalk ordinance, but as the applicant stated, the $300,000 was spent 3 years ago, and now when you combine that and the build out for the current building, that renovation is deemed half of the expense, and therefore the sidewalk bill has been triggered. So I think this case is a little bit different than our others, and the applicant has said that they were willing to put this up, build the ADA part out that is shown, and I think that's reasonable. And of course, board members, you know my opinion on the easy Ewing doctrine, that the council member of the district is here in person and asked to be let out of the sidewalk fund. I'm going to vote for that, so. Discussion.
Yeah, I'm okay with that. I think that, to me, at minimum, if they would, as part of this cleanup, you've got a pole and a lot of dirt, that if they would clean up that part of the sidewalk and make the corner ADA compliant, and then depending upon what the codes folks say, if they need to do more, they said they would be willing to do more, and I think that's up to that. But I think that if they were just to clean up the corner for sure, and then work with codes on the rest, I think that's a fair solution.
Okay. Do you want a motion on that?
Yeah, I will move that we grant the sidewalk variance. They've already testified that they have given the right of way, so that's not an issue, and that the conditions are that they make repairs on the Trinity Lane side as needed, where the two utility poles are, make the corner ADA compliant, and then work with codes to make any other adjustments on the Trinity Lane side that they need to their existing sidewalk. And as a result, there is no in lieu fund required on either side of the property.
Okay, motion's been made. Is there a second? Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. Good luck. Thank you. Okay, Ms. Lamb, what's next?
Next case is 2018-656 regarding property located at 3509B Renwood, requesting a 6-inch variance from the side setback requirements to allow an existing garage. Zoning map here shows the zoning of the property as R6. Aerial photograph of the property shows you the surrounding area. This is the site plan. And then this is the photographs of the property in its current condition, as well as across the street and up and down the street. There was opposition here earlier to this case.
There still is opposition?
There, I believe there's still opposition here, yes. So that being the case, Martin Dillingham is here. He's the appellant for the case. Mr. Dillingham, you'll have 10 minutes to make your desired presentation. Please state your name and address for the board, and if you would like to have some time for rebuttal, be sure to reserve that, because that will come out of your allotted 10 minutes.
Thank you. Oh, wow. Sorry. Hi, my name is Martin Dillingham. I live at 3509 Renwood Avenue. I'm here today to ask for a zoning variance for an existing garage. The garage that is in question was built in the 40s. This unfortunately, I wasn't able to provide you guys the documentation of the construction of the garage because that documentation didn't exist back in the 40s. So
Mayor Cummings' administration didn't keep good records? Is that what you're telling us?
Yeah, I don't think so exactly. So I have provided you with documentation of tax records that that do show the existence of this garage, as well as aerial photography from Google that shows the foundation of the garage here. The issue was that I had actually torn the walls of this garage down and replaced them because they were very rotten and it was actually a hazard. I found out that I was having a child that's due now in about a week, and I pulled the trigger and constructed the garage on the existing location, on the existing foundation. And so obviously I did not pull a permit.
I was about to say, the step you left out.
And so I'm sorry?
How do you access that garage?
It's a driveway next to the house. You could just barely see it in that photo.
So no permit.
So I did not pull a permit, and I have very much learned my lesson in not having pulled a permit through the process of coming here today and all of the processes that were necessary to get here.
Did you do the work yourself?
I did.
Okay.
And I have actually pulled the permit, and I've provided a copy of that permit to you as well.
Ms. Lamb, just for the people at home on Metro Nashville Network, what happens when you build something without a permit and you later get a permit? What is the penalty?
Well, if you later obtain the permit, there would not be a penalty, and that's, I guess, what he's here for today is the variance in order to be granted the permit. If the variance is not granted, if we determine that someone operates without a permit or has a building without a permit, presumably that would go to environmental court via the property standards for enforcement of our zoning code, which would require the permit.
So when they pay for their permit, they have to pay 3 times the amount what they would normally do?
Correct.
Okay.
And I would like to point out that that permit has been filed, and there's a copy of it in your documentation that I have provided for you. And there's also a copy of the permit status report that shows that the construction was good and that it would be approved on granting of this variance.
So all other aspects of the garage are up to code?
Everything is up to codes. It's been basically, it's been through the final inspection. It's just waiting on this variance per codes, or per the building inspector.
Okay. Questions for the applicant before we hear from the opposition? Have you talked to your council person or anybody?
I have, actually, it's Kathleen Murphy, and this case was actually originally on the docket for last month's hearing. I deferred to this hearing because she showed up and had spoken to a neighbor and was given information that was not correct.
You're not helping your case by...
I'm sorry?
You're not helping your case by telling us that someone who's duly elected to the Metro Council came up to us.
I have spoken with her since that, and she has become neutral, but unfortunately she's not able to be here today.
Okay, well, that's all. But
and so
by casting dispersions on the person that represents you does not help your case.
Okay.
Okay?
Yes.
Questions for the applicant? Okay. Do you have anything else to add? There's someone here in opposition. We'll hear from them, and then you'll have time for rebuttal to respond to what they have to say.
Thank you. I think that's all.
Okay. So go back in the audience. We're going to hear from the opposition. Please state your name, address, and why you're opposed to this particular variance. Press the button at the bottom. Just leave it on. Yep.
Hi, I'm Melissa Bouchard, and I'm at 3511A Renwood.
Donald Bouchard, her husband, at 3511A Renwood Avenue.
Okay, so you're nearby. So why are you in opposition to this?
So first of all, we are the next door neighbors to this, and this garage was built too close to our wooden privacy fence, which also connects to several other homes' wooden privacy fence. If you'll, I did submit a packet that I hope you all received. It was the last case that was actually deferred till today. We as the neighbors all have concern. We have a signed petition because this garage was only a slab, a concrete slab. The walls were erected in May, and had a building permit been filed and requested, none of us would be sitting here. So it's too close. We have safety concerns.
It's too close by how much?
By 6 inches, but the other issue that we have is not only that, but according to tax records, Mr. Dillingham's property is right around 780 square feet. The garage that he built is over 450 square feet. It should not be over 50% of what I'm sorry, it needs to be, I believe,
50%.
yeah, 50% of, so it can only, if it's 780 square feet is the original residential property side, it can only be 384 square feet, and it's larger than that.
Well, but that's an issue for codes to determine when they,
Well, here's the other thing. Mr. Dillingham, the only reason Mr. Dillingham got the permit was because we reported it. So I went down, I reported it. That's why you have the permit sitting in front of you.
So the permit was not filed until after the walls and construction.
And while you mention that, there's a wonderful use of technology now that everyone should have on their iPhone called Hub Nashville. If you've not downloaded Hub Nashville on your iPhone, you should, because you can report codes violations electronically.
That's exactly how I did it.
Oh, you did Hub Nashville?
Yeah.
My council person, Freddie O'Connell, actually, when a constituent calls him, he goes to Hub Nashville and says it's just as effective as he as a council person picking up the phone. So there is a lot of technology at our hands that, our hardworking code staff has a lot of issues to deal with, but that's a new way. Hub Nashville, if you go on the App Store, you can get it. So tell me this, so 6 inches, once again, that doesn't sound like a lot, but you all are obviously here.
I don't know where the pictures are that we sent. We put together a huge file with pictures. We also put together, here's the other issue we have. It shows in his backyard, you have to show, what is it called?
Well, there's plenty of room in the backyard. There was really no hardship here. The hardship was self-imposed. It was created by him. He had plenty of room to port the foundation over and to stay within the variances. Again, going back to had the building permit been filed from the beginning, he would have known the variances, and we wouldn't all be sitting here. So as the neighbors too, not only are we concerned about the structural integrity of the building, we're also concerned with the precedents. I can't just go and build something in my backyard and violate things and then ask for permission later.
well, I understand all that, but there's no shortage of cases that we've heard since I've been on this board where people have built structures like this on historical slabs that, that come to find out were very, very close to what it should have been, but weren't. And, I guess to me, there appears to have been a slab that had a historic structure on it of some point. I mean, they said there was a structure on it in the 40s and maybe longer. And so I guess I'm not sure. And I understand the precedent issue and all that, but that's not.
So then I guess my question would be.
Yeah, I'm still going. Give me a second, and then I'll let you speak. But I'm not worried about that, and that really isn't your worry. I'm worried about how it impacts you. How specifically does this cause you harm? Him being 6 inches closer to you on a historic slab than having him tear this thing down or take off that wall and move it 6 inches over.
So, in my opinion, and of the neighbors and my husband, I believe I speak on his behalf as well, the size of the garage is extremely large. There is no other accessory structure in our neighborhood currently of this size. It is almost as large as the front home. For resale value, it's going to decrease my property value.
How is it will decrease your property value being 6 inches closer? Because if it's up to code, and that's not what we're here for, there's nothing in our packet that says what he built isn't up to code other than this setback. If there are other issues, then they will be addressed, and maybe he'll have to come back, or maybe he's completely compliant and it's up to code. If it's up to code, how does, he could build the exact same structure 6 inches over, and all these other issues you're talking about would still be there. It's big, it's maybe unsightly, and that's in the eye of the beholder. I'm not saying that it's not fair or whatever. I'm just saying that all the reasons that you just told me you don't like it, don't relate to that 6 inches, that it's closer to me. So that's why I'm just trying to understand, and I'm not trying to be argumentative, but I really am. I understand a lot of the general complaints you have, but we're not addressing general complaints. We're addressing a 6-inch variance from the side of the yard.
I think we can make this very simple. Our biggest concern is this. We were fortunate enough to come to the last meeting. We had the pleasure of watching all of you talk to, different people coming in and discussing things like this. We didn't get that opportunity. We didn't get the opportunity to have, I've heard people here say, so what do your neighbors think of that? What did they say? You know what? I didn't get that opportunity. The bottom line is, at the end of the day, he built it over a weekend, and now I'm asked to deal with it. I don't think that's right. We put together, again, I don't know if you've seen it or not, but these pictures don't show anything like what that building looks like. I understand what you're saying, but at the end of the day, it was built the wrong way. The permit was not gotten, which he would have, if he had done that, he would have known what to do. And I will say this, Kathleen Murphy, we did speak with her that day, and all we said to her was, listen, the permit was gotten without, he didn't do it, then he built it. And at the end of the day, she said she was tired of seeing people in Nashville going and doing what they wanted and asking for forgiveness later. And I think that this just sets a precedent on, fine, if you want to say 6 inches, what's that? Well, I guess,
6 inches is a lot when you look at the proximity of the homes and the way that the fences are structured in the neighborhood. We're all very close. We're kind of those row houses, so 6 inches.
And I'm just asking you this because let's just, and I get the forgiveness. I don't like it at all. I've spent a lot of my life dealing with people who have done this. That said, that's our job, and maybe they'll double our pay. We get paid nothing, so it's all volunteer.
Sure.
Just FYI, but for having to deal with this, but let's say it was a case where there was a variance request and it was being asked to build a variance on a historic slab. Let's say he didn't do it without asking, and he said, hey, there's been a garage here before. It's been here for a long time. I want to build it on the historic slab. Those are cases that we hear a lot, and very frequently we say, yeah, that makes sense. Now, we would say, well, what do the neighbors think? And you would have a greater voice. But it really just comes down to me is I get the unfairness of it, and I get the feeling of unfairness, and I think that really is not a good thing. I definitely appreciate what you're saying there. But what I'm trying to figure out is truly what is the harm of the garage being there, and not simply to punish somebody for not going through the right process, but to judge objectively, is this a legitimate hardship, or is there a historic reason that the garage should be where it is?
I guess I just don't understand why the guidelines are put in place. Like when I read that, when I read down through things, it said, I get it. If there was an issue where, there was no room for him to build that, I understand. Wherever my pictures are, he has a whole nother side to his yard. All he had to do was pour 6 inches over. 6 inches. He didn't even have to pour the whole slab. If he pours 6 inches over, he's fine.
Are you saying he poured the slab, or was the slab?
No, the slab was there, but what I'm saying is if he's 6 inches off, he's got a whole side yard. All he had to do was, he didn't have to get rid of that slab. He could have just poured 6 inches more. But instead, and again, really what it comes down to is, yes, we're extremely frustrated. It looks horrible, especially to the neighborhood. As you can see, I don't know if you have our petition, 21 other people signed it on the street. They feel the same way. And I think that speaks volumes. How many times are people going to be able to do something like this, and then it just gets, well, it is what it is.
If we were to grant this variance, are there aesthetic conditions that would make this better? Should he paint it?
So the last time we were here for the meeting, I saw another couple come in, and they had been here several times. And they were looking to do a garage, and they had obtained a permit. They had met with the neighbors. They were back with renderings from the architect. They were going through that process. Again, this is it's here now, deal with it. Again, not saying that somebody can't build a garage, but let's do it the right way, and let's do it the way it seemed like everybody else that came through last time.
If you see the pictures, it looks like plywood with some with a, it's not even shingled, it's just
Well,
got
that's, I
some.
mean, I was looking at the permit, it said the value was like $3,000. So
Yeah.
that's pretty modest, I guess, right? So you're saying, to answer his question, is there anything aesthetically that you would?
Just so it would be within the scope of the neighborhood, right? The size, the scope, the setbacks, compliant,
I mean, if you're going to build something new, at least, I
Okay,
mean,
I'll ask again, because, once again, we're dealing with a 6-inch variance here on a historic slab. But is there anything aesthetically, you say you don't like the way it looks, what would make this a little bit better for your sight line being the neighbor to here?
move it over a little bit more from our fence. Again, decrease the scope of it, more characteristic of the neighborhood.
I mean, here's the thing, we don't, personally, I mean, we don't think it should have been built to begin with, but if you're asking that question, I feel like I'm giving in by saying, sure, would that make it, I guess, better? Are we going to be happy with that? I mean, I'm not thrilled with the fact that it isn't with anything in the scope of our neighborhood. Our neighbors feel that way. He knew what he was doing all along. All he knew he had to do was come and get the permit. At the end of the day, I mean, sure, just about anything would look better than what it is now. I mean, I'm not trying to be funny, I just don't know what to.
Well, I guess,
Any other questions for the,
I have a question. When you bought your house, was the garage that was on that platform, that kind
No,
of?
I will say this, if
Was
you
the
look,
old, excuse me.
I'm sorry.
Was the old garage still there when you bought your house?
and actually there were no walls, and again, within the documentation we sent, we can attest to that, as well as the neighbor next to him says there were no walls there.
she
Everything
wrote
was
a
down.
letter. It's in the packet.
It's in the packet that we
When
sent.
did you complain to codes?
I have
When?
When did you file your complaint?
I have the emails here, so it began.
Because it sounds like it started in March and it's
Yeah.
almost been a year.
In
So I just wanted to know what
October.
the timeframe was. You
Yeah.
all,
I filed it
I
through
mean, a
the,
lot of that's been, it's been deferred a couple, I mean, I get all that,
Yeah.
but I mean, he got his permit in October, but he started building something in March, and so when did you guys go, oh, this isn't kind of what?
so honestly, we travel a lot, and as my in-laws were in town, and including my father, said, this is awfully close to your fence. Is this within guidelines? And that's what made us
I want to say
start
it was roughly
researching.
September we probably started it, but I mean, again, to me, I mean, this has been hard. We came to the last meeting. We had to take time. And then he was here, and he deferred it at the last minute. So then we have to come back again. We took time off again. We had vacation planned. So we're here again. So I know that, sorry we had to wait a couple months, but we have lives too. And, again, he built it in a week. There would have been nothing we could do anyway. He built it over a weekend. We put pictures up of him, the building crew.
okay. Anything else for the opposition? Okay. Okay, well, come forward. Please state your name, your address, and why you're opposed.
Wayne Remedy.
I'll wait till you get to the microphone and everyone can hear you on the Metro Nashville network. Please press the button in the middle. See the red light? Yes, press the button in the middle. Okay, go.
Wayne Remedy, 3606 Pilcher, P like pizza, ILCHER Avenue, 37209. My signature is not one of the 21 that these folks said they called from their neighborhood. I am not personally acquainted with this property owner sitting behind me, but I frequently traverse in front of these folks' home, and this guy's resident. Peripherally, this individual is, and if we all don't know what scofflaw means, it's somebody that has no regard for the law. I called codes when he had an old car back there undercover. This guy doesn't care. I'm not surprised what this married couple's testified that has the hardship of living at 3511 Wrenwood. Ladies and gentlemen of this proceeding, I walked here. I walked by 3509 Wrenwood. I have a photograph here that was taken an hour and a half ago, right down the line of sight. If I could send it to John Michael, email, or Ms. Lamb, And if we have the technology, you could throw
Well,
it
let
up
me
on-
ask you this. So you walked here, you obviously care about this house. Why are you here in opposition? What makes this so egregious that you are here to speak out against?
His behavior is akin to somebody that sends a text without proofreading it, and then they read it after I meant. This behavior is akin to two new concerns going to drop another 1,000 electric scooter things on the streets of Nashville. It's like, do it first, and let's see if we get caught. It's like people with short-term rentals that don't live at the house.
Okay, back to this particular property. What is objectionable, what he has done or this building?
It is an eyesore.
Okay.
This individual imparted, it's the way it seemed to me like there was a garage there. There was not a garage there, as this gentleman stated. I never saw the slab because you can't see it from the street. I just think these folks very eloquently stated, I concur with sir and ma'am, right on down the line. It's like, hey, we'll do it first and see if we get caught. Then we'll straighten it up. Didn't go get a permit as required until this young lady went to Hub Nashville. I think the buck, or what have you, should stop here.
Okay. Questions for the opposition? Do you have anything else to add? Thank you. Let's hear from the applicant. It's rebuttal time.
Thank you.
Okay.
Thank you.
And the applicant, please come forward again, and this is rebuttal to could respond to what you heard from the opposition.
Yes, thank you. So there was a number of things that were said here. First of all, I'm not the type of person that is constantly going back and asking for forgiveness. The gentleman that joined here halfway through, he did mention a car that was back there, and I was keeping a friend of mine's car behind my house when he lost his house, and so it was on this slab exactly. So if he saw that car, it was sitting on this slab. Also, that gentleman specifically, the only way that I do know him is because he does frequently walk up and down my street. The only way that I know him is that he will stand in front of my house and yell at me, yelling profanities. It's actually well known in the neighborhood that he does this.
But we don't need to get into all that. Just
Cool. I'm not trying to get into all of that. That's the only way that I know who he is. He's never made a complaint to me about either my garage or my presence on the property.
So the other people, let's talk about. They say that you built 6 inches too close to their property
as
line.
as far as like the slab moving it 6 inches over, to move the slab over 6 inches, I would have to cut through a 70-year-old concrete slab to cut that part of the slab out, and then move the wall 6 inches over, and like support the building. And it would be a very large hardship to me to cut through that slab that has existed for that amount of time. The condition of the garage right now, yes.
Yeah, I just had asked about the slab. Would you have to move the slab? And the slab, from my quick talk with the zoning administrator, is not in violation. It's the wall.
Okay.
And so I guess, could you tell me what would be the difficulty in moving the wall 6 inches?
It would be basically I would have to construct another wall inside the wall to support the current wall, or the roof, the ceiling, and the other walls. Then I would have to rebuild the foundation and the other wall inside of that while I tear the other one out. It would probably cost me several $1,000s because of the deconstruction aspect of it. As I said, it only cost about $3,000 to build the entire thing, but when you have to add a whole lot of different steps to it, it would cost a couple $1,000 probably to remove the wall, but I have not had those estimates done myself. They did state that I built this garage over the weekend, and it was myself and some friends. It was not a construction crew that came over to build this wall. And as far as the scope of the neighborhood, I've been in this neighborhood for a very long time. The houses that...
How long?
Myself, I've lived in this house. I purchased it 5 years ago, but this property has been in my family since the late 70s when my father purchased the house. Then, as far as the scope of the neighborhood, when I did receive the stop work, which I did receive just the day before I got my permit, I received a stop work. I did not paint the property or the building yet. I have not painted the building, and I do have plans to paint the building. But it's not something that is an eyesore to the rest of the neighborhood. Unpainted, it does look like plywood.
It's because of the stop work order. Got it.
Exactly, and I just haven't completed it because I don't want to complete a bunch of stuff.
Anything else to
before
say
this.
to response to the opposition?
They did state that I had gone and built something without asking permission.
You didn't get a permit.
Yes, you're correct. And that I do apologize for, and I will obviously never do again. I never want to be in this position of having to come to the board again. And so, I do have the permit now, and, I've done everything that I can to, to satisfy everything that anyone has told me.
Okay, so questions for the applicant? Anyone have questions? Okay. Well, let's close the public hearing, and it's discussion time. Discussion. I'll start off and say, obviously this was on consent for a couple of meetings because it was a 6-inch variance. But as the testimony was heard today, it was built without a permit, although $3,000. So this is possibly, but on a historic foundation. So normally we get cases where someone has built something too close and it's a completed building and it's going to cost them maybe tens of thousands of dollars to fix. This is only a $3,000 construction job, albeit on a historic slab. So any thoughts about this case?
I totally appreciate the opposition's frustration, but I also know if it had been done correctly, the exact same structure would be there, again, provided that it's met all other code requirements, which are not on our docket. We can make that assumption because it's not on our docket. And the bulk of the issues of eyesore and that perspective would just be moot. And so that really is why I was quizzing on, what is the harm on this, knowing that if I was a neighbor and someone was asking for forgiveness of something I just didn't like, I would feel the same way. I'm very empathetic to it, but yet trying to figure out what's the right answer for this specific building. And I understand why it was on the consent agenda twice. It lines up with those types of cases that we have heard before that are in that regard. That said, we can talk about the effort it would take to move the wall over 6 inches, and is that too great an effort to ask in this case too? So I don't know if y'all have thoughts on that. We have our architects.
This is kind of a $3,000 unpainted kind of structure right now.
If it's moved over 6 inches, then, and I appreciate the opposition too, but they're still going to have the same issues with the materials, and I understand they don't like the construction, but if it's moved over 6 inches, those problems presumably will still be there. And I think what I see here is that it is just 6 inches, and there was a historic slab.
I do think if we approve it, that one of the criteria is that it needs to be painted to match the house. I think that is a fair compromise to.
And I think he said, he was going to paint it, but he got the stop work order. Anyone have a motion?
I will take a chance on a motion. I would move that we approve the variance as requested and make a requirement that the building gets painted.
Okay, motion's been made. Is there a second?
Second.
Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor of the motion signify by saying aye.
Aye.
And opposed? So, Christine, did you? You said aye. Okay, 4-1, passes. Okay, next case.
Thank you.
Next case for consideration by the board is
Or
case
5-1.
2018-663, regarding property located at 520 Raymond Street, requesting a special exception to construct an addition to a church. You'll see on the screen before you the zoning map showing the zoning of the property is RS 7.5. Aerial photograph of the property shows you the surrounding area. This is the site plan for the proposed addition to the church. Photographs of the current conditions of the property as well as across the street and up and down the street. There was someone here in opposition to this earlier. She's still here. Okay, so the appellant, you will now have 10 minutes to make your desired presentation for the board. Please make sure you identify yourself by name and address before speaking, and also if you want to reserve some time for rebuttal to the opposition, make sure you reserve that from your initial 10 minutes.
Okay, thank you. My name is Esmeralda Maya, 513 Radnor Street. I'm here along with
Julian Roberto Bustillo, and I'm the pastor on the church.
Okay, so why are we here? Tell us that you're trying to build an addition, and did you talk to your council person about this?
I'm talking to the person at the council.
We coming here to City Hall about try to get the permit for this kind of.
So you never spoke to your Metro Council person?
No, what he did was he came to get a permit and talk about if he could do it.
Yes.
And then he was mailed this, and then the hearing is on the appeal.
Okay, did you have a meeting in your neighborhood to talk about this?
No.
Ms. Lamb,
Yes, Mr. Chairman.
this is a special exception.
This is a special exception.
What do our rules say about special exceptions?
Per the Metro Code, I believe, for a special exception, there is a requirement for a meeting with the neighborhood. So
Since it has not happened here, what are we going to do?
it might be appropriate at this time for the board to defer this to give them an opportunity to have that neighborhood meeting.
Okay, so part of our rules, when you're asking for a special exception, which is not a variance, it's a little bit higher, you have to have a meeting in your neighborhood and allow people to hear about your plans, since a special exception is usually more involved. And that's part of the rules of the city to get one of these. Before it even comes to us, you're supposed to have that meeting. And considering there's opposition here, I think that's a good chance, and maybe you could explain to them what you're exactly going to do, and hopefully maybe you can have a dialogue with them, but involve your council person and have a scheduled meeting, and there are notices that are sent out to neighbors who are being impacted by this. So you have to talk to the staff of the codes department, and they will help you with the rules of that, okay? So we have two meetings. So let's have a motion to defer this a couple meetings.
So moved.
Okay, motion's been made to defer 2 meetings. Is there a second?
Second.
Motion's been made and properly seconded. Any discussion? Seeing none. All those in favor of the motion signify by saying aye. Aye. Opposed? Passes. So it's deferred 2 meetings, and you'll get with staff about this, okay? So, Ms. Lamb, what's next?
Next case for the board is case 2018-689. This case is involving property at 314 Duke Street, requesting a variance from lot size requirements to build 2 HPRs for a total of 4 units. You'll see here on the zoning map, the zoning of the property is R6A. Aerial photograph of the property shows you the surrounding area. This is the proposed site plan for the construction intended at the location. And these are the photographs showing you the current conditions of the property, as well as the photographs up and down the street. Is there anyone here in opposition to case 689? Seeing none, the appellant, Annetta Presley, is here, I believe, for the case.
Yes.
You'll have 5 minutes to make your presentation to the board. Please be sure to identify yourself by name and address before discussing presenting your case to the board.
Jessica Presley at 314 Duke Street. I know there was confusion the last time we came here about the situation, but I just wanted to try to come and clarify it just a little bit to give you an understanding of what we're dealing with. Anita has been living at 316 Duke Street for over 20 years and has inherited 314 about 8 years ago.
Okay, well, we'll cut to the chase here. This was a lot size variance.
Yes.
And the last time we heard this, the person that conveyed the property was supposed to convey more land, and if they had done that, we wouldn't be here. But they didn't do that. So what has happened since our last meeting?
Okay, well, let me give you the dates on when this was supposed to take place.
Well, I know what was supposed to take place. I just want to know, did you contact this person and say, hey, we got a signed contract here. You were supposed to convey this land, and did they do it?
No, we've been contacting them for 7 months.
And have you had any contact with them?
Yes, he tells us.
And what did he say?
He tells us every week he will get it done Friday. And every week it's not been done. There's
I will
always
gladly pay you Tuesday for a hamburger today.
That's pretty much it.
There are lawyers in this town that have to deal with people like that. Did you contact a lawyer and sue him?
She's in contact with the lawyer now to get that situated out. The only reason that we're here is because it's been months. We've been dealing with this since February.
We understand that, but you had a contract to get land that if you had the land that you were supposed to get, you wouldn't have to be in front of us.
Yes, but
And now you're asking us to fix it because you're a person who you entered an agreement with wouldn't.
yes,
And is still not doing it.
yes.
I guess I'm with Chairman Ewing on this too, is to really understand why is this not a legal contractual issue with you and your neighbor rather than us. I mean, it sounds like, if you had exhausted that, then, but,
Can she read our hardship? I mean, this is a hardship. We've been going through this for months on end. And I have contacted a lawyer, but our life is put on hold. I've been living out of boxes since September the 4th.
We were led to believe.
Have you hired a lawyer?
I have talked to a lawyer
That's
with
different from hiring a lawyer.
Okay, I'm waiting.
Hiring a lawyer, you give them money, and that lawyer writes a letter on stationery and files things with courts.
Well, we were advised to come here to avoid that situation.
And as I said the last meeting, you were supposed to get a certain amount of land, but let's hear from the councilperson.
Once again, of course, I'm not an attorney. There are few of you on here that are, especially our distinguished chairman. Believe it or not, once again, these are regular people that live in my neighborhood. These aren't the Tom Whites and the people that are trained in this sort of litigation. And as a council person, my job, I feel, and if you have a difference of opinion, it's okay. We still love each other, okay? But hiring a lawyer in litigation will put them farther behind. And if you can't, Mr. Chairman, Vice Chair people, and other codes inspectors and code staff, I'm asking that if the BZA can fix this, it will save them a great deal of expense and heartache, because unfortunately the other side has deeper pockets. And I believe, and I could be wrong, okay? And if the other side goes after, drags us out, they go through court, it'll cause a greater financial hardship on them than, and please,
So are they selling this land because they want to build 4 houses there, or are they the ones that are going to build these?
They are selling the land. The family is selling their land that they've lived on. And
so this is a perfect example. If you were to sell the land and say to somebody, hey, the BZA told us you could build 4 houses, but we hadn't done that yet. That's kind of where you are. You've basically bought some land and someone said, I'm going to give you all this land, and they held back 10 feet for whatever reason. And so you're going to turn around and flip this and then tell somebody else, And let me ask the question to our lawyer, actually, Ms. Lamb. Normally, these lot size variances, do these run with the land or run with the owner?
Any variance that is granted runs with the land.
Okay. So, board members, so if we give this variance, just goes with the land.
I probably need a refresher, and the applicant has a prepared statement. I'd like to hear that.
Okay, go ahead.
That's okay for the board.
Well, I'll just, because, just to save time, I'll just read like the bottom half of what I've had written. The agreement that we had with him was supposed to be filed after 6/15, which was when the properties behind us, he sold them. And that's in our legal agreement with him, which has nothing to do with you guys, but I just wanted to give you a time frame, and that's approximately 8 months ago. When we listed the properties, we were led to believe that it was filed at the deeds office already, and we had it in contract that we had that extra 10 footage, that the builders would be able to build the four on the lot. And because they couldn't pull that from the deeds office because it was never filed, it held us up in the contract with these people. They were willing to see if we could get it resolved. And in the 5 months we were in contract with them, we tried to get it resolved. We tried to get him to go and file it. He gave us an excuse every time that he was going to have it done on Friday every day, well, every week. And then we were advised by the real estate agent and everyone else to come here to see if we could go ahead and get it so that we could keep the contract of sale on the property and just move forward with it to go ahead and sell it. I attached pictures of the current neighborhood. Our houses are definitely not with the flow of the neighborhood, and my mother is just really wanting to get what's fair, because if we wouldn't have come here and said, well, we're in this and that with that, and maybe if a builder would have come here, you guys probably wouldn't have so many questions and it wouldn't be such, a problem of getting it passed through. We're just wanting to be done with this and get out of there and move on with our lives and not have to really take legal action against someone. And from our understanding, that when we come here, that it wouldn't take so much, we would be in and out is what we were led to believe. So we haven't really, been prepared to, we need to be in the process of suing this guy or however.
What did you get out of our last meeting that we had here?
That you guys wanted us to, I feel
Get
like
those
they didn't
10 feet
explain to
from
you
what-
all that we have not been in this for just 30 days. It's been months.
I know, but what we said was you
And-
need to get the 10 feet that you supposedly bought under contract from the guy that is not conveying it to you.
Yeah, we didn't have it in a contract to buy that from him.
No, that he was going to give that to you
Yes.
as part of the deal and for whatever reason didn't. And that's kind of a civil matter.
Okay.
Okay, I still need some refresher here.
Okay.
You own 314 Duke Street?
Yes, she does. Anita does. And she owns 316 as well.
And 316. And you've owned that property for many years?
Yes.
Both
Yes.
properties?
Close to 20 years, yes.
Okay. And then,
And my mother, when she passed, the other was left to me.
okay. And then 309B, can't read very well today, 309B Prince Avenue, which is behind your property. When did that go for sale, and that's the person you're fighting with?
Well, he's already sold the properties. Then one of them, so 309 was sold on 5/31, and then 307 was sold on 6/15. And according to our agreement, he was supposed to have the 10-foot conveyance filed 15 days after those properties were sold.
And he was conveying the 10 feet to you for what reason?
For exchange for on 316, the entire
My backyard.
the entire backyard pretty much was not hers, but there's pictures of it. There was a chain link fence that connected the entire back across of it. So he took all the way up to her back porch slab. So on that property now, there's no backyard. And for the agreement, because he knew we were wanting to sell the properties. So in the agreement, he went ahead and said, well, you guys let me do this, don't fight me for it to have it grandfathered in, and I'll give you the 10 footage so you guys can get a fair price when you
On
guys
the
go to
other
sell on the other lot.
You can draw for me on this exhibit or exhibit you might have where this 10 feet is. I'm getting confused.
It's on the back, it would be on the back side of the property. I think I gave.
Of 314.
I think it's to the immediate
Yeah.
south of the highlighted property on the zoning map on the screen now.
Yeah,
Ms.
and it
Carpenter.
would be just the 10 foot would go back on there if he would have given it to us.
So here, about 10 feet wide.
I don't actually have that one in front of me, but it would be in the rear, it'd be where 309 and 307 are, like on that side, where of Prince Street.
Well, I don't see a 307, but I only see a 309, a 305, and a 311.
Okay, well, I think 307 is behind 316, so I guess it's 309. There's an A and a B there. There's pictures. I took pictures. You could see them from 314's backyard.
Any other questions for the applicant?
Ma'am, you said you'd spoken to a lawyer. Have you not been able to afford a lawyer?
When I went and talked to the lawyer, it cost me $150 that day. He called Justin Hicks to see if they could resolve it, which he told him the same thing he told us, it'll be there Friday. Friday has never got there. So he suggested me to another lawyer that would take my case. I'm not made of money. I am going to sue this man, but I still want to move on with my life. What he did is wrong. Wrong. It's a breach contract. I don't have no bunch of money. But I am going to still try to sue this man. But I want to move on with my life. This has been months.
We basically came here to get an answer from you of how she needs to proceed.
What I need to
proceed
do.
to the
I just wanna
lawyer.
move on with my life.
Because if you guys give us a yes, then we can't really sue him for a 10 foot. And if you give us a no.
I got to know what I'm suing him
then
for.
we could still sue him, but not, I don't think for an entire contract amount that we had our properties.
Yeah, I pulled out of the contract. I'm out of the contract, period, because I'm tired of waiting on this. What am I going to sue this guy for?
Okay,
I got
so
to know what I'm doing.
Which contract are you pulled out of?
We pulled out of the contract for sale because we could not get the 10 foot from him.
So, as
And
it
we
is
had
right
lost two
now,
properties
you
that we
could
were on
build how many
contract with.
houses on this? 2 or 3?
I think the current situation that it's on, I think it's 2.
I'm not sure how.
I think.
Councilman?
I think I can provide, and I pray that I can help provide some more clarification. They had individual homes. Even though they're a family, they love each other, I'm going to miss them on that street. I used to live on Queen Street, so I know the Presleys, okay? I went to school with their cousin that was here helping them last time. What has happened here? They had a contract to buy 2 other homes, okay, and they lost that because of this issue with the 10 feet. Now, and if I'm wrong, please forgive me. Back in the, I don't want to say back in the day, but before the 2 new houses on the other street, they thought, because sometimes in that side of the county, people would build their fences over, and maybe not exactly on their property line. I know Codes Department deals with that a lot sometimes, where people built fences, maybe not exactly on their line. But I guess that the 10 feet, the 10 feet that they're talking about, when they lost their backyard, which was originally not their backyard, but for all those years, everybody thought it was their backyard. Yeah. But now we find out when it's time to build these 2 homes that it's not their backyard, However, the builder, at least I'm thinking, kind of wants to make things kosher, says, if I want to take your backyard, maybe I can give you additional 10 feet. And now I have 2 new residents that are there in those 2 great houses, which are wonderful people. And one resident was okay with it, and I'm not trying to hold this against the other resident, because I don't want to put a battle with my 2 newer residents against my other residents there. It's one of the difficult things as a council member, not trying to balance this stuff. But, one of them called down to planning or the codes department to ask if they gave up the 10 feet or the 5 feet, which since there's 2 units on there, I guess each one will be giving up 5 feet. They said they will have an incompliant lot. And sometimes when you tell someone that's not familiar with the governmental process that something will be incompliant, they panic, which maybe we all should. And so they're like, well, even though we signed it at closing for our 2 houses, because the developer did one thing right on this, was he made the residents sign that they knew they were going to lose 10 feet, but he didn't file the deed. And I just don't want to see either side punished. And I'm sorry to come in front of you guys and be like, BZA, please wave your magical wand, and fix this. You know what I mean? But once again, whatever you decide, me, I'm going to be fine with it. But, I'm just trying to help the regular people in my neighborhood.
So I want to hear from our newest BZA member, Ross Pepper, who deals with a lot of real estate issues. So what's your take on this?
It's a mess, and I'm very empathetic to where you are, but what I see is that I don't think there's a hardship here, because I think you have a legal remedy that you can exercise, and that's kind of where I come down on it. I'm sorry. I understand it's a mess. I understand you should have gotten this 10 feet. But I think, and I know it takes longer when you go to court, believe me, I know. But I think that's just part of it, and that's where you need to be.
And I think that's what we said at our last meeting, that there's some legal remedies that need to be exercised before you come to us, that we were not going to bail out the neighbor by giving you this variance when he should have, according to you, conveyed this land and registered it, and then you wouldn't need us. So that is your remedy. Is there any other questions from the board before? Okay. We're going to close the public hearing. Discussion.
Well, I'll probably be the soft-hearted one today.
Okay.
And we've granted other lot size variances for various reasons, and all cases are different, and this is not setting a precedent, and we haven't set a precedent with other cases. But just given the fact that we have granted lot size variances, I'm actually okay with the variance request.
Is that a motion? What's it based on?
It would be based on what's that language that David Harper likes to use that language, and I can't remember what it is.
Ms. Karpenick is likely referring to the other exceptional circumstances language out of the Tennessee State
Which
Code
we
at
used to call the
13-7.
Herbert section, but now we'll have to call the Michael section, Mr. Zoning Administrator.
Pretty sure that's still the Herbert section, Mr. Chairman.
The catch-all category.
So that would be the motion to approve based on the exceptional circumstances.
Okay, motion's been made. Is there a second? Motion dies because there's no second. Okay, anyone else have a motion?
I'm going to make a motion that we deny the variance. I'm very sympathetic to the situation, but I frankly don't really, I think Mr. Pepper has accurately said there's another remedy here. I do not believe we are the right body to assist these parties, and I wish you good luck. That's my motion.
Okay, motion's been made. Is there a second? Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Okay, passes 4-2. Ms. Lamb, next case.
Next case for the board is case number 708 regarding property at 909 Joseph Avenue. requesting a variance from sidewalk requirements in order to construct a single-family residence without building sidewalks. Is the appellant here on this case? Are you the appellant on this case? Yes. Okay. Before you, board members, you'll see the zoning map indicating that the zoning property is SP on this particular property. Aerial photography shows you the surrounding areas. This is the proposed site plan for the construction at the intended location. And finally, the photograph showing you the view of the current conditions of the property as well as across the street and up and down the street. Is there anyone here in opposition to case 708? Seeing no opposition, the appellant is FBGM LLC. Looks like they have a representative here. If you will please state your name and address for the court before making your presentation, you'll have 5 minutes to make your presentation.
Okay, sure. Hello, my name is Bethany Burkhart. The property is 909 Joseph Avenue, Nashville, Tennessee 37207. I'm requesting a variance from the sidewalk requirements to construct a sidewalk and also not to pay into the in lieu of fund. What happened was I was going to construct an addition and also remodel of a single-family home, and what had occurred is that when the framing inspector came and took a look at the house, he said that when you double the square footage of a house, you have to go get a new construction permit, and you also and it kicks the ordinance into effect where I have to construct a sidewalk. But photos here show that there are already 8-foot sidewalks along both sides of this street, and the sidewalk is in good condition.
Yeah, good condition? These look like they were built in the Fulton administration. These are not.
I mean, they don't have cracks, and there's not real divots. I mean, there's discoloration from weather, but I mean.
Okay, continue.
There's the joint cracks that are in a grid pattern. Those are supposed to be there because concrete will eventually crack, but you can control where it cracks with the control joints.
So tell us, you built this accessory dwelling for what use?
It's
detached? Oh, you built a new house. Okay.
Well, it's a remodel and addition. So I took what was before, the footprint of that house, and then redid the first floor and then added a second story.
Oh, so that, I mean, for all practical purposes, this is a new house. Did it look like the house is across the street?
Well, I pulled the appropriate permit.
Okay.
I'm sorry.
Did it look like the house is across the street, sort of?
No.
Kind of what did it look like before you?
It was a square, essentially.
So you went out and up?
No, I did not go out. I just kept the same footprint and then went up.
How many square feet were the original structure versus what you built?
It was a little over 1,100 square feet, or 1,200 square feet.
And then what's the square footage now?
A little, so 2,400, so I think it was 1,200, so now it's 2,400.
But it looks like the third story has front dormers, so that's...
That's not a third story, it's just a false roof front. I just added dormers on top.
It's not living spaces?
No.
What's up there?
It's attic space.
Okay.
I would not welcome you to live in there. It's not comfortable.
I'm sure you're aware, because you have your councilperson there, about the sidewalk requirements and bills, so why are you saying that you shouldn't have to pay?
Well, because the sidewalk is already there, and I believe that I've already improved the neighborhood because the house that was sitting there was not structurally sound, so I had to redo a lot of what was there because I don't like covering up structurally deficient messes that people have made before. So I have done extensive remodeling to the structure on the inside to make sure that the floors are level and...
Okay, got it. Okay, Councilman Davis, your constituent, why are you here?
Well, still a little dazed from the last case, but I'll get over it a little bit. You know what I mean? I'm a big boy. Mainly right here is, A, I'm being consistent. I would like for them to dedicate the potential right-of-way, that rule.
I've already
Oh, you
done.
already done that? Cool. Thank you. And right now, I would like and I'm very consistent, because I have other cases just like this coming up with my constituents. I'm wanting to waive the in lieu fee, and sidewalk is there. Granted, it's not the prettiest sidewalk, but it's functional. And the house that was there before this remodel caused me a lot more problems, and that may be personal due to being the burden of the council member, dealing with those neighbors that you have to pray about a lot. But at the same time, I'm going to be consistent.
Gotcha.
I'm asking nicely,
Okay.
please waive the sidewalk requirements and the in lieu
Consistent
fee.
Davis. So, questions for the applicant? Okay, and board members will know I'm consistent. You know how I'm going to vote on this. So, anything else to add? Okay, we're going to close the public hearing. Discussion.
I think that yeah, I'm with you at the right of way.
Okay, do you have a motion? Okay, well, I will I will make a motion that we approve case 708 due to the fact that this was a remodel and not a total new build, and that the council person has enthusiastically shown up in support and is in favor of this variance. Okay, motion's been made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Okay, 5-1. Next case. Good luck.
Next case is case 2018-713 regarding property at 305 Hancock Street, requesting a variance from height restrictions to construct a detached dwelling unit that is 25 feet in height. Is Ms. Hancock here for this case? Yes, she's here. So board members, before you, you have the zoning map showing you the zoning of the property as SP, aerial photography showing you the sense of the surrounding area, as well as the proposed site plan, and finally the photograph showing you the current conditions of the property, as well as across the street and up and down the street. Is there anyone here in opposition to case 713? All right, seeing no opposition, Ms. Collins is here. She's the appellant and I believe owner of the property. You'll have 5 minutes to make your case before the board. Please be sure to identify yourself by name and address.
Okay. My name is Tracy Collins. The address is 305 Hancock Street, Nashville 37207.
Okay, so tell us why we're here. We have a height restriction and a sidewalk variance. Ms. Lamb, tell us what the Metro Code says about accessory dwellings and height compared to the original.
According to the Metro Code, the accessory dwelling can be no taller than the primary structure. In this particular case, I believe the primary structure is 18 feet in height, but I also think the zoning code limits it to 17 feet. So the maximum height that Ms. Collins could have is 17 feet for her accessory structure. She's requesting 25 feet.
Is that for all dados or?
That is, yes, I believe for all dados.
And that's to the eave, not to the roof?
Correct.
So, because when they measured it, I mean, in their drawing, it seemed to me that the 25 foot was to the top of the roof. See what I'm saying? Is that because of orientation? You see what I'm saying?
Yeah, I had similar questions when I looked at it as well.
Okay, well, ask those similar questions.
No, it's exactly what
Okay. Okay, please tell us why you're here and why you want to build this accessory structure at that height.
Also, can you clarify there is no sidewalk variance request, is there?
Yeah, there's no sidewalk variance request.
Oh, okay.
Yeah.
This doesn't trigger the sidewalk bill? So you're going to pay into the fund?
You're not seeking a
I don't know what the sidewalk.
Unless it has the value of our home.
Oh, okay. Well, maybe it doesn't. Okay, just continue.
Okay. Yeah, so my plan originally, and I'd been working with our neighborhood and Scott for the last 5 years, getting the whole Dadu thing to be able to happen. And so my plan was to build an accessory dwelling by my house. But in the last couple of years, with all of the restaurants and everything that have moved in, on-street parking has become an issue. So instead, I'm trying to build a garage and have the accessory dwelling above it. My house is currently 18 feet, so in order just to get any type of square footage, I need a height variance to make it cost effective. I mean, it's so expensive to build that for 300 square feet, it's not. So I'm just trying to get some living space. I need some height in order for that to happen.
Okay, any questions of the applicant?
Yeah, I mean, I guess the only confusion I don't have an issue so far with what I see, because it contextual. I mean, you have a historic house that has a little lower roof. The historic house next to you has a higher roof. It looks like the 25 feet is somewhere in between, at least based on the drawing you saw. So, I mean, contextually, it seems like it's not inappropriate. But the only question I have is that the drawing. The drawing shows that you all submitted. It shows 25 feet is the ridge height of the accessory dwelling. I mean, that it won't be anything. It's not the eave, right? I mean, I think a lot of times you measure to the eave, and it can be taller that way. So, but I guess you're asking. You're just asking for a height variance because of your home is shorter.
Right.
Okay.
Yes. Yeah. And the other thing is we're trying to keep like the aesthetics of the home, like the pitch of the roof, like similar to the house, instead of making it like, if you flatten out the roof, you get more height. I mean, more space.
I mean, I guess that my main concern is that you're building a Dadu to Dadu standards, meaning that you're not asking for any variance from the regular Dadu standards. You're just asking to be able to build a 25-foot tall Dadu because your house is 18 feet tall.
Yeah, I mean, the guidelines currently allow, I think the maximum you can build is 25 feet with a 750 square foot footprint. So I'm just asking to be able to build what's.
I would like to ask Ms. Lamb to clarify that height with the eaves and all of that too.
Yeah, so clarification to what I said. I believe the law on its face, black letter law, says eave. The consistent application of that law by codes has been to the ridge line of the roof, simply because it is often difficult to determine what exactly would constitute an eave. Additionally, the potential of an eave being height and then the roof line going, miles if it wanted to. So the reason that we're here today is because when the application came in, we did, as we consistently do, to the ridge line, that can be no taller, A, than the primary structure, and B, no taller than 17 feet in height. And as her drawing shows, it's 25 feet to the ridge line of the roof.
Okay, so that's a little bit different, so it's actually ridge line. Okay. Other questions for the applicant?
So can you tell me your hardship again? I didn't quite follow it.
Originally, it was just going to be an accessory dwelling. But because the changes in the neighborhood over the last couple of years, parking has become a problem. We have a new popular restaurant, more to come. We have a dog park. So even being able to park on our street is a problem. So I wanted to change the plans to make a garage with the accessory dwelling above it. So then I need the height to be able to do that.
Okay. Do you have parking availability? Can you access from the alley? I assume you can.
Yes.
And could you put a parking place next to this Dadu without an uncovered parking place?
I mean, technically, I'm sure you could, yes.
Okay.
Yeah.
Any other questions for the applicant?
Is your house? I mean, if you look at this, overhead, your house with the dot is 18 feet, or the other, I think the house to the left from the street picture looked like it was much taller.
Yeah, the house.
Or the other, and then the one to the right is it's not a historical home.
Right.
But the ones to the right of it appear to be.
They're all.
Overhead, are they taller than your house? Is your house?
Yes.
I mean, it seems like the one with the second to the left with the blue roof is definitely taller.
It's taller. Across this, yeah, all the three across the street, well, there's actually four, they're all taller.
So it's so.
And we also have behind is a commercial building, a Ward Plumbing building, that's also.
2 stories.
Yeah, and I think there's plans to turn that into
Okay.
some stuff.
Any other questions of the applicant? Okay, we'll close the public hearing. Discussion.
I mean, to me, it looks like one of those cases where you have, you are the historic home that 100 years ago was 1 story and everybody else's was 1.5 or 2. And, to me, since it's sitting as far back in the lot as it is, and again, we're not the Metro Historic Commission, but, and I don't know what they would do, but I know one of the things that they tend to say they'd like to do is, see something from the street, and I don't think this is something that's going to tower over the existing home because of its placement.
And it's, particularly in the rear of the property, too.
It appears to be designed in a way to complement the historic home. And to me, if there's, other than the exceptional circumstance, I think, is the fact that most of the historic homes that we've identified would allow this. Her home was a 1-story home and wouldn't. And I'm not sure what the harm is. And I think the fact that the councilman has come is testament that there is no harm to the neighbors. So
okay. Do you have a motion?
Well, I'll move that we approve the height variance, provided that all the other Metro Code requirements for a day-do are met, based on the historic nature of the home and the contextual height of the other historic homes on the street.
Okay, motion's been made. Is there a second? Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Oh, okay, 5-1. Passes. Good luck. Ms. Lamb, can we take a break?
We certainly can do that. We will take a quick 5-minute break and reconvene after that break. Mr. Rahimi?
Yes. As Mr. Taylor pointed out, this is our first real 2019 case. Wow.
Indeed. The appellant's not here, however, so
I guess
it's up to the board how to handle this first case.
Well, let's put it to the next meeting. Okay? We'll move to defer it to the next meeting. Is there a second? Motion's been made and properly second. All those in favor signify by saying aye. Aye. Opposed? Okay. We'll try to get a first case of 2019. How about the next one?
The next case is, it's 2019-005. I would point out, Mr. Chairman, there are 5 cases that are all the same property and the same property owner, just asking for making multiple requests to the board. So we divided the requests up. However, at your discretion, I think it might make the most sense to hear them all together.
Okay, well, let's hear them all together, and you can present the case,
votes.
and we'll take the separate votes.
So this property involved in this particular, these requests is 4117 Gallatin Pike. As you'll see here, the zoning map shows that the zoning is OR 20A. Aerial photography giving you a sense of the surrounding area. This is the site plan for the proposed construction intended at this location. And these are the photographs showing you the current conditions of the property as well as across the street and up and down the street. In these cases, again, multiple cases, but the requests that are being made are for, in order to construct an addition to an office, he's requesting variance from parking requirements, the front build-to zone as well as the rear setback. variance from the sidewalk requirements, as well as landscape and rear buffer requirements, and then finally, a variance from the street access requirements. Is there anyone here in opposition to these cases? Seeing no opposition, he will technically have 5 minutes per case, I believe, so that would be 25 minutes. Mr. Michael Woods is here. He's the appellant, I believe, and owner of the property. You will now have technically 25 minutes if you need all 25 minutes.
I am Michael Woods.
Okay. Get us started, please.
Not the owner of the property.
Name, address, why you're here.
Michael Woods, I'm the contractor, or hopefully the contractor. The property is 4117 Gallup Pike. We were wanting to construct or add about 3,100 square feet to the property, and that
What
brought
building is this right now?
This is a chiropractic office.
Okay.
So how big is the office now?
It is 2,780 square feet.
And you're going to add 3,300, so it'll be a 6,000 square foot?
Add 3,100, so it'll be 5,800 roughly.
Okay. And then, I don't know if they said, but I know the variance for parking requirements, how many parking spaces are required and how many are you asking for?
Well, right now, there are 26 existing, and basically, I know there's different requirements for medical office versus regular office. And I think for his existing, which I guess would be considered a medical office, there's 14. You would need 14 spaces. And I believe.
Need 14 additional spaces, so that I'm clear.
Well, no, it goes to the, if we have to change our entrance, which I believe is it's 009. It was the street access requirements. Basically, we were told that we would have to change that down to one entrance, and if we did that, that would change the flow of the traffic in the parking lot.
Mr. Vice Chairman, in case it helps the appellant kind of explain that on the parking, what has been identified by our zoning examiner, Mr. Thermopoulos, was a required count of 29 in this instance. The request presented to the board and at the time of the application was to have 18 parking spaces. Again, part of having multiple requests within this is if A, then B, sort of an analysis in terms of the front set or the front build-to zone requirement, the parking count, the landscape buffer, and lots of other amendments to what would otherwise be by the book required by the zoning code to this piece of land. To begin, though, the parking count required here is 29. The request is for 18, thus a reduction of 11. I hope that helps some.
Does it make sense, if we're going to look at these 5 requests, that we do the front and rear setback first, because does the size of the facility that we allow affect these other things?
We can.
Okay, can we do that first?
Basically, if you look at the site plan, it shows where we would be adding the building to the rear. It crosses the rear setback line. I think it goes over about 2.5 feet and goes back down. I think it crosses the line for maybe 16 feet. That was the only setback that we were trying to get a variance on.
Okay, what is the required setback?
20 feet.
I mean, talk to me about the front first. The required setback is 20?
I can't read it from here, but.
On the front, I think I can answer that for you. The front is a build-to zone in this particular zoning area, and so you have to build up to, it's different from a setback. You have to build up to closer to the street. The minimum build-to zone for this is it has to be built no farther back from the street than 80 feet. He's requesting to build it back 130 feet. So he's requesting to build it back 50 feet farther from the street than he is required.
Okay. And is the rear the same way?
No, the rear is a setback, and the rear setback is 20 feet, and he's requesting to build 17.6 feet. So that's a roughly 2.5-foot rear setback request.
Okay, what is the reason you want to have your building almost double back?
To double back?
You want to be 150 feet back from the street?
No, I just want to add the I can't see that one up there, but we wanted to add I don't know what it is on here, but we wanted to add a certain distance back off of the rear of the existing building, which then becomes 2 feet over the setback.
I think she's talking about the front, though. The build to is 8 feet, and you want to build to what? Pardon me?
The build-to line is 80 feet.
80 feet, and you want to build to 150?
No.
I'm sorry. Okay, can you explain the front? Because I'm
The
trying to get
front
along.
has nothing at all to do with it. I'm not going anywhere out the front of the building. I'm only going to add to the side of the building and the rear of the building.
Okay, it just said a variance from the front. So
Yes, and I don't know why.
That's not accurate.
No, that is true. That's what Emily just explained. They're supposed to build at minimum 80 feet. 80 feet is the furthest back they can go, and I think they're at 100 and something, 120. But as he said, they're building in line with where the existing building is. That's what he's proposing to build in line with where the existing building is. It's just too far back, according to the current code. And then at the rear of the property, he's got, because the building's a little off skew, he's that little sliver in the back goes over the lot. But he has to have both variances because he's not supposed to build back as far as the existing building is now.
There's a permit tracking sheet in our files. It looks like this, and it has a lot of information that might be helpful to everyone. If you all find that, it's where
Yeah,
looks
I was
like
looking
that.
at that, all right, yeah.
I guess, what are we, I mean, to me, all these kind of go hand in hand. I mean, the question in my mind is how, I mean, especially on the parking is, you're more than doubling your space. I guess, is it all chiropractic clinic?
No, the new space is going to be tenant space.
Wait a minute.
So you'll have, what kind of tenant?
Just office.
So you'll have office in 3,100 square feet, and you'll have chiropractic in the remaining existing.
Yes, sir.
And so how is 18 spaces adequate for?
I think that was not correctly portrayed. I have 26 now. I don't want to take away from any of my parking.
But you're building all this new space. Where are those people going to park?
In the same parking lot. The building that's there now.
How many spaces do your chiropractor people take up?
Well, I've never seen it full. I'm not the chiropractor, so.
How many employees work at that office?
I believe 4.
Okay, and so how many customers come at any given time?
I don't really know how to answer that because I'm not the chiropractor.
That's a pretty important point here.
What does the addition include? What kind of space?
It's just going to be 3,100 square feet of office space. Yes. The required amount of parking spaces was, I think, 1 parking space for every 200 square feet for medical, which would give you 14 parking spaces that you need for the existing chiropractor.
And so you're asking for also variance from the street access requirements, which is to allow you to keep the existing entrances and exits, which gives you more spaces than
Yes, if we had to
18
take that.
versus. So that would be required 29 and you have 26. So I guess this is a little bit of the chicken and egg
But here's where we are. You're asking for a lot of different variances. Have you talked to your council person?
The owner of the building has sent them these letters, and I don't know that he.
I'm going to face-to-face talk to your council person, because it seems to me, and you say you may be the contractor on this, what will make you, so you're not even the contractor right now?
I've been appointed as the spokesperson for the owner of the building.
Okay.
And Mr. Chairman, I would point out that the council member, I believe, sent an email regarding her position on these.
Yeah, but what I'm getting at here is, you don't even know some of the most basic information about how many people come to the chiropractic office and what kind of office is this going to be? And I'm just not sure if we have enough information to give all these variances kind of the attention that they need if you don't know basic stuff about what's going to be built and what this is used for, because it's pretty material, the use of this building and what's going to be offered there.
Well, they haven't been able to actually figure out who's moving into the space because they don't know if they can add on to the building.
Yeah, I mean, and that may be, you may have a little bit of a court. I've already used chicken and egg, so I'll use cart and horse. In cases like this that you want, I mean, you're asking for one, like five variances, 1, 2, 3, 4, 5 variances. I mean, as a general rule, any renovation that wants 5 variances, I mean, that just is a red flag to say you probably shouldn't be doing this. But now if you look at each one of them separately, you think, well, maybe you got a good, maybe you got an argument for it. But at least on the cases that have been successful, and I'm not saying you will be if you do this, but the ones that have been successful have, had a lot more drawings and said, this is what I'm talking about. I know you have a proposed site plan, which, lays out the land you want to use, but what I see is a massive building without a plan A and B, for the parking. And as you said, you don't know who's going to go into it. So, what if it's another, what if it isn't an office? What if it is a
restaurant or,
what if all of a sudden it's retail and we've given you a parking variance and there's no place to park? And so, I think with those things and the council member saying, I'm not for it, I think there's more homework to do.
Yeah, I think you need to come back with us with a little bit more specifics.
More detailed plan, talk with the council person.
And maybe you need to scale this down to see if there's something the council person will accept, because she just blanketly said no.
She did.
Well, the email has, that we have says, yeah, I'm inclined not to support any of this. Let me know if I'm missing something.
And normally, when you ask for these amount of things, it goes in front of the council, not us, as a zoning change or request. And you're just kind of piecing together a bunch of variances, and which might be a de facto way of trying to backdoor something that should have gone to the Metro Council.
Okay.
And so I think a whole lot more discussion needs to go on, and a whole lot more information needs to come to us before we even rule on this case.
Yeah, I mean, and that's a conversation to have with her, and to say, what would you support? How could, do you come out the front? Do you come out the back? Do you come out the side? What do you do to add on to your property and yet meet, as many code requirements as you can? And if you can't meet the code requirements and there's a good hardship for it, then, you come back to us with the council
And
support.
have you talked
That's
to
a whole lot easier.
Have you talked to the urban forester about your landscape buffer request?
Yes, and I think the main reason we were doing that was because we had I think it was going to be a 20-foot wide buffer that would be required.
Is he supportive of your request?
He seemed to be when we spoke to him.
Seemed to be.
Well, he didn't, he said he couldn't give me an answer one way or the other without an actual drawing.
Well, that's what we're saying. We need more information.
Okay.
So
Yes,
we need to defer this. So
okay.
Let's, how?
What would be, is that give you enough time?
Yes, sir.
Okay.
I'll move that we defer this to the first meeting of February.
Okay, motion's been made. Is there a second?
Second.
Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Passes. See you in February.
And my motion was to defer cases 05 through 09.
Okay, very good. Ms. Lamb, what's next?
Next case is 2019-010. Property at issue here is 1238C McGavick Pike, requesting a sidewalk variance to construct 2 single-family homes without building sidewalks or paying into the fund. Zoning map here shows the zoning as R8. Aerial photo shows the surrounding area and gives you a sense of that surrounding area. Site plan here shows you the proposed construction intended at this location, and finally the photographs show you the current conditions of the property as well as across the street and up and down the street. Is there anyone here in opposition to case 010?
Okay, let's get started. Name, address, and why are you here?
Mitchell Pollard, 2017 Aberdeen Way, Old Hickory, Tennessee. We are requesting a sidewalk variance here at the corner of Huffin and McGavick Pike. I don't know if those photographs are given, if you can see, but in the front of the property, and as well as the side, there's sanitary sewer that runs in the front behind the existing sidewalk, as well as storm drainage, I'm sorry. And so if we were to attempt to construct the sidewalk per the code, we would have to redirect or redesign the existing infrastructure of the sanitary sewer and the
All
storm.
that's true, and the council kind of anticipated this, and they created a sidewalk fund. So why not pay into the fund, and you don't have to worry about building into that ditch?
Well, actually, that's why I was here the next. And after looking at it, we've come back and said that we wouldn't have a problem. We'd be okay with paying into the fund. The Planning Commission recommended that as well, paying into the fund on the McGavick's portion of it.
Are you fine with that?
Yes.
Okay. Well, that's just.
So you're okay with the Planning Commission recommendations?
Okay. Okay. We'll close the public hearing. Motion.
Yeah, I mean, I'll move that we approve the sidewalk variance request for this property with the conditions that the existing sidewalk be maintained in a good state of repair. Any portion of the existing sidewalk that's not ADA compliant is to be removed and made compliant, which appears to be none in the photograph. The applicant shall contribute the in lieu fee for the McGavick Pike property frontage, but not the property frontage on the other side.
Okay. Motion's been made. Is there a second? Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes. Last regular case. Thank you. No. I guess he didn't. Last regular case before the short term. So.
Case 2019-016. Is the appellant here on this application?
Case number, the 8th Avenue, the North 8th Street property, Vernon Kesey.
All right.
Can this be deferred?
Okay.
He lives across the street from the property that he's being held with.
Okay. So Councilman Davis has stayed here all this time and he doesn't even show up. So
One meeting?
He had an emergency.
okay. So one meeting, Councilman.
Please.
Okay.
I'll move that we defer this until the January 17th, the
January
second
17th.
meeting of January.
Okay. Motion's been made. Is there a second? Motion was made and properly seconded. Any discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Passes. Good luck tonight, the council. Councilman Davis. We're at the short-term portion. Ms. Lamb.
Mr. Chairman, the first short-term rental case for the board's consideration is case number 2018-595 involving property at 1414A Boscobel Street. Is Tyler Inglett here today? Okay, so Mr. Chairman, this case, in this particular case, the appellant is challenging the denial of a short-term rental application. Our office denied this particular application due to the ordinance, which requires that only one permit may be issued on a lot in single and two-family zoning districts, as well as that ownership of two-family dwelling units may not be divided. They have to be owned by the same person. In this particular instance, 1414B Boscobel obtained a short-term rental permit in 2016. That particular property is owned by a different person. Thus, when Mr. Inglett came in to apply, he fell under the current law, which prohibits a second short-term rental permit on that lot. Is there anyone here in opposition to case 595? Mr. Inglett, you'll have 5 minutes to make your presentation. If you'd please introduce yourself by name and address.
Tyler Inglett, 1414A Boscobel, 37206.
Why is the zoning administrator wrong on this?
Excuse me?
Why is the zoning administrator wrong on this?
Well, I purchased this in September of this year from Giselle Collada. Am I saying that right? Okay. They've been operating it as a short-term rental, owner-occupant short-term rental since around August of 2016. August 4th, 2016. And they were also initially denied the short-term rental owner-occupant because B-side had the investor owner-occupant, which is a company out of Brentwood.
Do you understand what Ms. Lamb said, that this is only one per lot and the neighbor has one and you don't?
I do understand that. And so my argument is that Mr. Collada also had to come here and he got an exception.
Is that true, Ms. Lamb? When did he get his permit?
August
4th, 2016, I was here.
Did you get it before the other person?
They got
No,
it after.
got it after.
Person.
He needs to come up.
So the way I'm looking at
If you're
it,
going to testify, come up here and sit.
Okay.
Okay. Name, address.
My name is Eddie Cox. I'm a real estate agent. I am with Keller Williams Realty, and my address is 145 Anderson Lane in Hendersonville, Tennessee.
Okay. We don't have anybody from our short-term rental department, so John Michael, help us out here.
Mr. Cox, was that a young couple that I recall having filed a case before the BZA with regard to this?
Yes, sir, and I was here. I was their witness.
Great. Here's what I remember about that, Mr. Chairman. The young couple's case was ultimately withdrawn and the matter was resolved administratively. It's 100% accurate that they did obtain a short-term rental permit and that did constitute a second permit on that lot. That naturally would not have normally been the case, particularly under the current state of the law. However, because of the resolution of the issue that had led to the denial of the permit at the application level, there was no need for the board to pass a motion of any sort. Therefore, there is no order on the books because the board never had an order on that case. It was withdrawn or resolved administratively. Although that happens rarely, as you know, it does happen from time to time. Now what comes before you is Mr. Inglett's request to obtain a permit. He will explain his rationale, and I think at present it sounds like it's going down the road of because the prior folks had that. However, the law has changed multiple times since 2016, as all of you know, and as they know as well, having met with Mr. Inglett previously. He and I have talked through this to some extent. I don't say that to color his appeal one way or the other, just to acknowledge that we've talked about it some. The current state of the law, number one, does not allow two short-term rental permits on the same HPR lot. That would be the case here as long as the first one still exists, or one of them still exists, either being the case. And then secondly, the law no longer allows the issuance of a short-term rental permit at an HPR or two-family development specifically when there is a split of ownership, such that if David Ewing owned Unit A and Cindy Chappell owned Unit B, no dice. Nobody gets a short-term rental permit there.
So the other neighbor who says they say has a short-term rental permit, technically he's not
Has
eligible?
and has had one for quite some time and has had one since before Council Bill number 608 from last year.
So he can keep it until he sells it?
That's right.
Okay.
Or as long as they're still eligible and continue to renew, but yes.
Okay. So this particular case, under current Metro law, there's no way for this particular property isn't eligible for many reasons to have a short-term permit because the other one next door has one and it's on this divided ownership HPR.
The more fundamental is that you can't have two on one lot under the current state of the law, and that was the primary basis by which we at the zoning level denied the application for the new short-term rental permit.
Okay.
And the fact that a previous owner had it as soon as it changes ownership, then the previous permit is canceled, and the new owner would have to have a permit and would have to apply on current law.
Okay. Questions for the applicant? Do you have anything else to add?
Yeah, so my argument here is because whatever the exception was that they were given to get the short-term rental permit, I believe that I should have that right too. It's going to be an owner-occupant short-term rental instead of an investor-owned short-term rental. I've talked to both neighbors on each side of the person that lives, let's see, I've actually got her signature here. Let's see. Can't really pronounce her last name. It's At 1412 Boscobel, that is my neighbor directly beside me, Daniel Schalabach or something like that. I got his wife's signature on the letter that we had to send out to all the neighbors.
Have you talked to your councilman about this?
I haven't.
Well, this Councilman Withers has talked to us. He's written us an email. Dear members of the Board of Zoning Appeals, I'm writing to express that I cannot support the appeal to allow an STR permit at 1414A Boscobel Street, as there's already an STR permit at 1414B Boscobel Street on the same duplex zone parcel. The Metro Council early on in its current term agreed to limit STR permits to no more than one permit per lot. I joined Councilman Berkeley Allen as co-sponsor of Ordinance BL 2015-94, which added this one permit per lot cap, and it passed on third and final reading January of 2016. He goes on to say, I've received emails from neighbors living on the same block as this property expressing opposition to this appeal, and therefore I must join the neighbors in opposition. So he's pretty clear. He passed a law on January 2016 that prevented more than one on this block. So how do you respond to that?
January 2016, correct?
Yeah, but you're asking today. Because
well, on August 4th, 2016, they were granted, the previous owner was granted the short-term rental permit on this property. So in my eyes, that sets a precedent on this property.
if they gave a permit in error, they would have revoked it, or, John Michael, how do we respond to that?
Can I finish what I was saying about the neighbors? Okay, so I've talked to the neighbors right beside me, and of course, they've lived there for like 3 years, and so for the last 2 years, when it was a short-term rental permit, I asked them, I said, have you ever had a problem with A side? And they said no. There's a young couple with a newborn. They said they never had an issue. I talked to the other neighbor at 1416 that lives beside the B side, which is investor owned, which means that they don't screen the people that come rent it. They just want it rented. And she says she's had problem after problem after problem. I'm going to be screening everybody that
How
rents.
do you do, I mean, I'm not familiar with
You do it through Airbnb.
but if I click on somebody's property and rent it, Airbnb gets to screen, not you.
No, you get to screen it.
So you could
You can go on Airbnb and say, no, you're not renting it.
Based on what?
Feedback.
Based on what?
Feedback. They have a rating.
What if I have 5 stars? You can't reject me. Can you?
Yes.
You know you can. I don't think so. Okay.
But there's a way to communicate with that person that's trying to rent it.
Okay, so
you can ask questions.
So this is a different situation than him just being an investor trying to rent to everybody he possibly can and churn and burn the money and through the property. He owns it. He takes a vested interest in it. And if an investor is able to make money on it, why shouldn't an owner-occupant be able to make money too?
But what the Metro Council has clearly stated was there's only one permit allowed per parcel, and your neighbor has a permit. And so this is now not eligible. So how do you get around that?
The same way that these people got around it.
Well,
They came before you.
Mr. Chairman, you asked us to address that earlier. My best recollection from 2016 is that the then zoning administrator reviewed the case of the folks who had applied for a permit, had been in extensive correspondence back and forth with one of the zoning examiners who was handling the permit application, and it was determined by the zoning administrator that some of the information was sufficiently confusing, misleading, or otherwise inaccurate. I don't pin any of those individual words because I honestly don't remember, but something along those lines, such that he thought it was appropriate to grant the permit despite the 2016 legislation that created the one per lot restriction. That law is still applicable, so if that was the basis, and it is my best recollection, Mr. Cox may have a completely different recollection, but that's my best recollection of the basis by which the prior property owners obtained their permit. That doesn't seem to be the case here because Mr. England wisely came in to talk to our staff early on, wisely came in to talk to me after being discouraged by and I think that's a fair description, discouraged by the answer that he got from us.
I'm just trying to do everything the right way.
I'm going to finish what I'm saying here.
Sorry.
You did try to do everything the right way. You came in and applied. We gave you a good straight answer, no, you're not eligible because this would be a second permit on that lot. You then came to meet with me, as I best recall, where I reiterated, no, you're not eligible because you're not allowed to have more than one on that lot. So if the basis of the folks getting a permit in 2016 was that they had received incorrect information or confusing information, whether or not I agreed with that or you agree with that, the zoning administrator determined that was an appropriate basis to resolve the matter administratively and not have this go for a final vote before the BZA. Barring any demonstration that you received inaccurate information with regard to the law that is in play, the applicability of that law, and the subsequent laws that have come through since January of 2016, and regrettably there have been a collection of those laws that we've all had to try to keep up with, including poor Mr. England who bought this property trying to keep up with all these changes in laws just like everybody else has. Barring that, it's a completely different set of facts which in no way have precedential reference to the 2016 instance. Of course, the chairman likes to remind folks even more frequently than we and staff do that there is actually no precedent before the Board of Zoning Appeals. Every permit is different. Every piece of land is different. In this case, the law that was applicable to the applications has been made different by 3 or 4 ordinances that have passed since January 1 of 2016. However, I think that correctly captures what happened in 16, why it's fundamentally different from what's happened here in 2018, and although it in and of itself isn't determinative as to how you should vote one way or the other on the appeal properly brought forward by the appellant, it does explain how we got where we got and why we got there. We still maintain that we correctly determined that this property is not eligible for a permit at this time.
Very good. You have less than a minute left on your time, so closing remarks.
Well, my closing remark would still be the same thing, you know. If I understand correctly, so a mistake was made, and then they were granted the short-term rental permit.
Well, I have a question.
Sure.
So if the neighbor at 1414B is really a bad apple, then somebody could report them to Metro Codes, and if they had 3 strikes, then they would come before us and we would maybe revoke their permit, or, and if that happened, then he would be eligible?
And
If under any circumstances, the permit at the other part of this lot went away because they failed to renew it, because it was revoked, because they sold it to somebody else, for any reason, then immediately Mr. England's property would be potentially eligible for a short-term rental permit if they came in and timely applied.
And I would point out, my understanding is that this particular property is an HPR, and the potentially eligible, but the current law says that the ownership can't be divided. So even if the 1414B permit would be grandfathered under the law that existed at the time the permit was granted, in the event that particular permit were canceled or otherwise done away with, the current law in effect now is that ownership can't be divided. So Mr. England would have to own both properties in order to get the permit.
Okay. Any other remarks? Okay, close the public hearing. Discussion.
I don't see that we have any evidence in front of us to find that the zoning administrator erred. The law in effect today is what he ruled on, and that's my position.
I agree with that.
Does anyone have a motion?
I move to uphold the zoning administrator's denial of the short-term rental permit.
Okay, motion's been made. Is there a second?
I'll second.
Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor signify by saying aye.
Aye.
Aye. Opposed? Passes unanimously. Next case.
Next case, 2018-606, regarding property at 2619 Essex Place. You'll see the aerial photography showing you the property as well as the surrounding area. This case was previously heard on December 13th, and the board deferred it so that Ann Ballard, who's the owner of the property, could appear. Mr. McBroom is here on behalf of staff. If there are any questions, he can make the presentation on behalf of staff, and Ms. Ballard is here to make her presentation as well.
Okay, Mr. McBroom, tell us about this case. How did you hear about it, and any other violations besides not having a permit?
This was a result of a host letter. They located the advertisement and sent the letter. The first online activity occurred in July 26th of 17. There were 95 documented stays total. February the 9th, a host cease and desist letter was sent. Estimated delivery of that letter was on the 17th of February. There were 8 documented stays in February, no documented stays afterward. February the 24th, first BZA appeal was filed. The website ad was removed on March the 2nd of 18. The appeal was subsequently withdrawn on the 5th of March, and then a second appeal was filed on the 28th of September. It was deferred on the December 13th meeting. There were no documented complaints, and there were no other actions taken.
Any questions for Mr. Broom? Okay, nope. Thank you. Please get us started. Name, address, why you were here. Please press the button at the bottom. Keep it. Yep.
Thank you. My name's Ann Ballard. My address is 2619 Essex Place, Nashville 37212.
Okay.
These are 2 of my many children.
Okay. So why are we here? What happened?
Why
didn't you
are
have
we
a
here?
permit?
Pardon?
Why did you operate short-term rentals
I
without a permit?
operated short-term rental without a permit because frankly I procrastinated and I thought I would get to it and I didn't get to it.
So you knew about the law and you just didn't bother to fill
It's
it
not
out?
that I didn't bother. I had all the paperwork. Was traveling out of the country to bring a couple more kids home. I just didn't get it done.
But in the
So-
interim, you continued to take money from short-term rental people and rent without a permit?
Yeah, and quite frankly, I mean, I was kind of encouraged by other people who'd been doing it, get to the permit later, don't worry about it, it's no big deal.
People
So,
told you to
yes.
get to the permit later? It's no big
Oh, I had,
deal?
yeah, I mean, the reason I even started was because one of my friends said, I can't believe you're not doing this. And I was like, why? What are you talking about? And she explained it to me, and I went ahead
And when
and
she
did
explained it to you, she told you about the permitting process?
She said, yeah, lots of people do it without a permit, don't worry about it. So I just procrastinated. It's not like I didn't mean to, but I procrastinated. So then when they said stop, I stopped, and that was kind of it.
Did you remove all the other future postings when you
Oh,
got
yeah,
the letter?
and I think
How many?
there were a lot. There
What's
were
a
lots
lot?
of
20,
postings
30?
through, like there were postings through like almost the rest of the year.
Okay, but how many?
But I
You
stopped them
cancel them all?
Yep. I
Okay.
tried to do it through, I'll tell you how that happened. I tried to do it through Airbnb.
Mm-hmm.
Well, I started doing it on my own through Airbnb because I didn't know there was another avenue. And they were charging me $25 for every cancellation, and then it was 50, and then it was 100. So finally I called them and I said, I'm trying to cancel these. I'm going to go broke canceling them. Can you help me? And they said, yeah, and they shut the whole thing down and then refunded all their fees that they'd taken from me.
Okay, Mr. McBroom is back.
So.
Is it no big, oh, you're, okay.
So what day was the last day that you rented the property? About?
I'm going to say it's right after I got the
March,
letter. Yeah.
March of 18?
Yeah, yeah,
And then, and this is your home?
yeah,
And you're there when people are there?
yeah.
Any questions for the applicant?
You have a neighbor that seems to, Mr. Honeycutt, seems to think you don't live in the property.
I'm there in the property. I have another home in Maryland. I live in the property. I'm there about half the month. I have, well, a couple of reasons I'm in Maryland. Wherever I work, I can work from wherever. So I travel a lot for work. And as I have 6 young children, 5 are adopted, 1 is a foster son. He's with DCS here. So I'm down here with him so he can have his visits that he has with his biological family. I spend time in Maryland, obviously, with the rest of my kids sometime, good part of the time. And also my oldest son lives there, and he's has some health issues, so I'm trying to help him and his new family out a little bit. Yeah.
Okay.
Any other questions? Okay, we'll close the public hearing. Discussion. Everyone's Everyone's looking at Mr. Taylor, who,
Well, I mean, I'm not sure when the clock starts ticking at codes, but if you rented prior, if it's from the application date or the last rental, but, I think that if the offenses that were described in terms of the neighbor's letter, partying or whatever, if they were viewed to be extreme, then I think the worst case we would say is that 9 to 12 months, and it's been 10 months almost since the last rental. So that's,
So do you have a motion?
Yeah, I mean, I'll move that the zoning administrator didn't err that the applicant rented without a permit because the last documented rental was in March. The applicant will be eligible to apply for a permit on January 15th.
Okay, motion's been made. Is there a second?
A second.
Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes 5-1. And next, before we start our next case, I actually have to go. So Speaker Ryan is handing the gavel over to Speaker Pelosi. Run our meeting. We'll see you next.
Next case for the board is going to be case 2018-662. Property is involved is 1014B West Grove Avenue. The board will likely recall that this was heard at the previous hearing, or previous meeting rather, on December 20th, and a deferral was granted. So Mr. Collins is here again on behalf of the appellant, or he is the appellant rather on behalf of the owner of the property. So I will let Mr. Collins make his case. This is a property, if you recall, the issue here is in regards to change of ownership and whether or not that the permit would be allowed now.
Thank you. And 5 minutes, you said we got? Okay. Just to catch up, and I'll let her pass those out, I think. Okay, perfect. Many of you heard that packet or heard what we went over last time, so I'll save you the details. But I would like to get back to the meat of the issue, and that meat of that issue is when this final, if you want to call it a transfer, happened in January 21st of 2016. If you look at what the state law says, it reverts back to what the law would have been at the time. The ordinance in effect at the time in 2016 would have been 951 and 909. These bills, 2014-951 and BL 2014-909, are what established the Metro Code 628-030. Later on, after in this interim period, so 6.28.030 was repealed on February 21st of 2017. They took away 6.28.030. So effectively, we're trying to apply a law that has been, that the law said, the state law now says you have to apply a law that was the law at the time, but the law then was subsequently repealed completely and totally invalidated. So we have to play this little history lesson. The point of bringing that up is this. When 951 was enacted, it said, it laid out 250E. And 250E was the very first time it would have ever been brought to formulation. And at that time, it only said, these are all accessory uses. And then you go back to whether it's a denial or any of that. So now when you see 250E, it's massive. It's 7 or 8 sections with subsections, A's, B's, and all of that. At the time, it was only saying it was an accessory use. Also, what it said is denial or revocation of a permit. That if the zoning administrator finds or determines that there is a violation of law, be it here in this case a transfer or otherwise, they may then revoke the permit. Doesn't say shall, doesn't say is required to. It says it may revoke the permit. Well, instead of revoking the permit at that time after there had been a transfer, this was then renewed again and again. When the zoning administrator has the ability or the choice, really, to revoke a permit and doesn't do so, you're now telling every single person that's been renewed this permit or given the right to have this permit, you have that expectation that they had the option and they chose not to. A lot of times, and if you are familiar with the CAPS case that a lot of times Metro leans on, the very basic difference in that case is in that CAPS case where Metro government was fighting a variance in the Cabernet down here and they didn't want it, the Natural Resources Commission didn't want it. And eventually it was said, the Metro can come back and do whatever they need to do anytime they want. The big difference there is the notice. Every single person in the CAPS case was on notice within days, and the appeal was filed a week later. What we're doing effectively now is saying the zoning administrator is not charged with finding out whether or not someone is in a permit status that is applicable, and then maybe later sometime down the road we'll figure it out. The reason it's an error is because they didn't catch it. Had they caught it at the time in 2016, they would have been able to get their permit exactly as it is today. The hardship here is if we deny the permit and say you can't have it, now they have to apply new regulations which would effectively render it unable for them to get a permit. The question is,
So remind us again of why, because it's been a while and we've heard a lot of these, and what specifically would have allowed them to get the permit had they caught it? I thought that there was like a month between.
8 days.
So they transferred it back, but I thought that was after the bill. I thought that was John's testimony, or not testimony, but John's comment last time was that was after the bill had gone into effect.
951 and 909 had gone into effect.
In March.
In February. February. Then that was repealed later in 17 in February, but it was renewed again in March of 17. It was renewed, the transfers all happened in 16, renewed in 17. Ability to revoke was available in 17 to the zoning administrator. Did not happen until March of 18, when they were denied the renewal.
I thought that in 17, when the transfer happened in 16, but I thought that the law was in place. Is that not right?
951 and 909 was in place, which is why I attached it.
And so, Mr. Collins, I asked you to defer last time, and the reason was you put together obviously a very studied and thoughtful brief, and I didn't, as I said, my mind was kind of mush. We were getting towards the end of the day, and I didn't have the Tennessee statutes you were relying on in front of me. So I went back and looked at those, the TCA code. So what I wanted to check was your position in what you filed previously was that because the STRP was renewed, this STRP is grandfathered within the meaning of 13, this is the Tennessee Code 13-76023A. And I wanted to go look at that and the rest of the statute. And I don't think 13-76023A applies because there's no question this was used as a short-term rental. And that section you cite is the definitional section of the Tennessee Code on short-term rental unit act. So it really doesn't do anything but define what used as a short-term rental unit means. So if I look to, I think what the meat of that act is 13-7603, which says, except as otherwise provided, an ordinance, resolution, regulation, rule, or other requirement of any type that effectively prohibits, or otherwise regulates the use of short-term property as a short-term rental unit shall not apply to property if the property was being used as a short-term rental unit by the owner of the property prior to the enactment of the ordinance, which we all agree was the case. But it also says, and this is where I think the zoning administrator did not err, and it's clear to me as a matter of law. I understand the equities of your case, and I'm sorry you had to defer and wait, but I felt like I really needed to read this stuff. And what it says is, and here's the key part of it: the ordinance, resolution, regulation, rule, or other requirement in effect at the time of the property began being used as a short-term rental unit is the law that governs the use of the property as a short-term rental unit. And I think that's what you're trying to hang your hat on, except that it then says, until the property is sold, transferred, ceases being used as a short-term rental. And we did have a transfer here, right? We had a transfer in June of 2016. So to me, if there's a transfer of the property, then you can't look to the law that was in effect prior. Am I missing something there?
I think that's where I'm glad you brought that up, because if you look at Exhibit 5, the letter that was addressed to my clients.
Right, let me pull that out.
Sure. They put the date of transfer as June 21st, and they cite 17-16-250E. So if we're saying that there's no question that they were holding it out as a short-term rental after that effective date of the 21st, then there has been no transfer. Secondly, I would like to point out that within the body of 951, and specifically,
let me get to 951,
sure,
if you would.
I'll pull that up. I had it on my notes. But.
Okay, I'm looking at 951.
It's exhaustive, but at the same time, it talks about the permit. The permit being transferred, there shouldn't be, and if you read at section, it's on the second page of 951.
Okay, can you give me a
P?
E?
P.
P, okay, let me get there. Okay.
A permit, an STRP permit shall not be transferred or assigned to another eventual. There's the transfer language. And Q then talks about 3% and all that. And this was an argument that's been made to you before, and I understand your position on it, but I kind of wanted to explore it a little bit more, because TBCI, or 1, however you want to look at it, was always the permit holder. And while in 951 it talks about how no entity, it didn't bring up that entity information in 951. So the permit holder, the person that was the person holding the permit, never changed. And in fact, and that's why I get back to this transfer language, because if on the 21st is what the zoning administrator is hanging his hat, that's when the transfer happened. And 951 gives the zoning administrator the ability to, it doesn't say shall, it says may then revoke or may deny the renewal. Because that did not happen, you then give the permit holder the expectation that it's going to continue.
And I understand, but I think what you're trying to hang your hat on what the zoning administrator didn't do, and that's not convincing to me. I don't think it gets you past the law to say the zoning administrator shouldn't have kept renewing this permit. I understand it seems inequitable. I understand this property was only transferred for 8 days, but this is an item A appeal, and in going back and looking at these statutes, which I wanted to do, I have to come to the conclusion that the zoning administrator did not err based on these statutes. I just don't think that the fact that you can't say the law doesn't apply because somebody in the government should have notified me of something. And I think that's what your argument is.
So just so I understand for my purposes, if you're saying that the state law doesn't apply at all because there was a transfer.
Right, that's what I'm saying. It says, again, going back to 13-7603, the ordinance, resolution, regulation, rule, or other requirement in effect at the time the property began being used as a short-term rental unit is the law that governs the use of the property as a short-term rental unit until the property is sold or transferred. And there was unquestionably a transfer here.
So just going along that line, and this is why it's the second part of my argument. If we say that the transfer has happened, and on June 21st, 2016, this has been transferred, but we also say that there's no question that after that date, after this transfer, it was being held out as a short-term rental, and it had a permit, then I think you have to either talk about the state law again and apply it from transfer forward.
Well, but I think it shouldn't have had a permit. That's the issue, because you had a change of ownership.
But how, and there's the problem. If the error is made or not made, or if you don't think it's an error, and someone is then renewed, we're given that permit again. There's no notice to them whatsoever that, I mean, Metro continued to take taxes, they continued to take all of those things, and I understand it. It's not necessarily an equitable argument. It's also, Metro on one hand is acting like it's valid and saying it's valid, but on the other hand saying, you know what, we made a mistake, it's not valid. So they're holding themselves out to say that it's valid.
Well, and I understand in the ideal world, Metro, you want Metro to notify you, but there was notice out there. The law had changed. And even though a lot of us don't know about laws changing, it doesn't, we're still bound by them. And I think that's your dilemma. And I wanted to go back again and look at this statute. I felt like you did a very thorough job, and I didn't have the statute in front of me last time, and I think your avenue of relief here is a statute, but I think the phrase "until the property is transferred" just undercuts your argument.
And back to what we were centrally talking about, and please don't allow me to beat the dead horse, but at the same time, had they known, and that's the difference, we wouldn't be here. They would have a permit. They would have exactly the permit that they originally had, because nothing in the law prohibited them from being able to get that permit.
And I totally agree with you. I totally agree with you that if your client would have known about it, this would have happened. But again, this is an item A appeal, and the question is, did the zoning administrator apply the law correctly? And I believe he did, and it's unfortunate, but we all are bound by laws that, when they change, even if we don't know about them, it can have unfortunate consequences like this. And I understand if your client would have known about it, we wouldn't be here. But it happened, and as a matter of law, I think this state statute just doesn't help you.
Well, and the only thing I would say to follow up on that is, I fall back to what I originally said. When in the law it has, the zoning administrator may, but not shall. How else, seriously, how else are people to know, or how do we temper expectations if you get renewed a permit? Like, what happens if the law changes in the future that says you can't have a permit if you live on a street named 1014A? Does then the state law apply? I mean, it's one of those things where we're saying they're penalized because the law changed, even though at the time they were following the laws in front of them. And only because, and they continue to do so and continue to think that they would, because the zoning administrator had a choice and chose not to deny it. And that's the thing. If there's a choice by the zoning administrator, they may, and they choose not to, then the logical conclusion is, okay, I'm fine.
Right, but the law still required that if there was a change of ownership, the permit needed to be changed, and that didn't happen. I understand your argument.
I don't think it did require it, because it says here's the restrictions, but then it gives the zoning administrator latitude, because it says may. It doesn't say this is the law, now I have to revoke it. It says I can revoke it.
And that's 951 you're talking about?
That's not just 951. It's the current status of 250E in every section under denial. If specifically you want to look at 951, If you look on the second page of R subsection 2,
The language you just quoted to me, that the zoning administrator may, that it's discretionary, where do you find that?
if you look on 951,
All right,
R, denial or revocation of a permit, then you've got 1 and a 2, and then you go to subsection 2. If the Department of Codes Administration determines that violations of this section or any other ordinance or law relating to SDRPs have occurred, the permit to operate a SDRP may be revoked.
okay.
Mr. Pepper, if I may add some commentary that will fit in with what Mr. Collins is walking through, he's correctly identified the discretionary language that was afforded to the zoning administrator under 951 with regard to revocations. Revocations, consistently from the inception of this regulatory schematic, have been treated as actions that are taken in response to violations in the field, something that equates to bad behavior, if you will, noise violations, parking in the grass violations, inflatable dolls strapped to front doors in East Nashville violations, if theoretically something like that would ever happen. However, the cancellation in this instance we treat as different from a revocation for bad actions. I don't think there's any evidence, testimony, or suggestion that there have been bad actions by the permit holder and operator of the short-term rental permit here. Instead, we have something that is a function of law. Upon change of ownership, by function of law, a permit expires. Now, I understand Mr. Collins has, of course, advanced his argument with regard to whether this temporary transfer of ownership rises to the level of a change of ownership. Obviously, the zoning administrator determined that it did. But we don't treat that as a revocation for bad action. Instead, something that on the date of that transfer, whatever the date was in, I think you said 2016, the permit ceased to exist that day. To have characterized the subsequent renewals by zoning staff as a choice to renew suggests a thoroughly informed and correctly analyzed decision. That, however, as has been discussed previously, was not the case. It was in error that I, then the chief zoning examiner, now the zoning administrator, approved that for renewal. So, similarly, one might say, if I drove in here at 85 miles an hour on I-65 today and didn't get a ticket, and therefore I think it's okay to drive 85 every day, it doesn't change the fact that the speed limit's always been posted at 65 and 55 when you get into the city's core. It's a matter of what Judge Higgins, a judge that Mr. Collins and I have both argued in front of a number of times, would call a story of the caught and the uncaught. At some point, we, the uncaught, eventually become the caught, and that was the case here.
I understand. And I think also the permit was revoked. I mean, at some point, the zoning administrator did. I understand your position is, well, but it was renewed for at least 2 years or 3 years before it was revoked, but yet it was revoked.
And I guess I fall back on Mr. Michael's testimony and Exhibit 5. In fact, it says a cancellation. So if the caught and the uncaught, I mean, I have to say that Metro is caught as well because they didn't deny that permit. If we're going to say it's a denial, not a revocation, then they applied for a renewal of a permit, and Metro has consistently said this is a 365-day permit. They renewed it. They did not deny it. In fact, they gave it to them again.
I guess trying to ask, the thing and I don't know how relevant it is, but I'm still trying to convince myself. I don't know, I don't want to say something that's going to offend anybody. I'm trying to determine whether I believe that the permit would have been renewed under the existing law. And so I view it as, I ran a stop sign. It was caught on camera. The camera wasn't reviewed till 2 years later. What fine do I pay? The fine today or the fine when I ran the stop sign? And yet, I don't know exactly what I thought when we went through this before, and maybe it was another case because we've had a couple of these that were change of ownership cases recently, but.
I was going to say, Mr. Collins is probably well equipped to take up the question. Now, I understand your implied question to be if upon the transfer of ownership in June of 2016, if they had come in the next day and made a new application under the new ownership name, which law would have applied? Would they have been eligible? Talk through that.
At that time.
And that's what I'd like to, that is, but I'd like for you all to And it may address the equity issue more than the legal issue. I don't know. I mean, but I just really want to understand that in this.
951 would have applied, in my understanding.
Yeah, go through the dates again so that they can.
Sure, and I'll just, I've got it, I don't know if they gave you the packets, but May 1st of 15 was the initial time they got the permit. April 18th of 16, they renewed the permit. Again, on March 31st of 17, they renewed the permit. So we've got 15, you get the permit, April of 16, you renew the permit, March of 31 of 17, you renew the permit. Transfer happened June 13 of 16, and then back into the same owner June 21 of 16. 951 was repealed by 492 in February of 17.
And as you're jotting down that timeline, Mr. Taylor, did I understand your implied question to be if a new owner, upon transfer of that property in June of 16, had come in and made a new application, would they have been eligible for the permit on that day? Is that kind of where you were trying to go in your analysis of the equities? Yeah. And as 951 was, would that have been a non-owner occupied permit application, I presume?
That would have been a non-owner occupied, and then you would have, and as 951 I provided, it would have been, then you could look at Q of 951, and that's where it talks about, that's when we had the 3% of the single family or detached two-family residential units non-owner occupied. So that's.
With that caveat, the answer is potentially it could have been eligible. There was no restriction on type 2, then called type 2 permits in our zoning districts at that time.
But the next logical time the next logical time for codes to have looked at it, because there's no reason to think that codes would have looked at it in June of 16 after it was renewed in April, would be in March of 17. And what was, maybe that was where I was getting caught up, was what was.
And that would have been 492. I still think they would have been able to get the permit. I don't have 492 in front of me, so I apologize for that.
Mr. Collins is correct that 492 did not have the outright ban on new type 2 permits in our zoning districts. That was a product of 608, not 492. There was still the 3% cap, so the same caveat applies. Board members who have been with us a while will remember the odious analysis of a 3% of the total number of single and two-family units in a given census tract. Fortunately, we had a little tool that was built by the folks at the planning department to help us figure that out, or we never would have. So thank you to them for that once again. However, we don't know that today, but assuming, if one does, that there were permits available within that 3% cap, within that census tract on the date of the application, then it is potential they would have been eligible for a permit at that time.
After they had been told that they would have had to appeal to the BZA because they rented without a permit that they lost in June.
Well, actually,
So
this is an important caveat.
That would have added some time to it. I mean, if they came in March to apply and you said, hey, y'all transferred the property in June, sorry.
So what we have done with instances where folks have operated for what I'll refer to as the remainder of the year, if they had a transfer mid-year, this is a great example, March renewal, June transfer, come back the next March of 17 to renew again. Because folks had no idea they were operating in violation, although the law has been clean since its inception, and our application of that law has been consistent since its inception, the reality is that these folks didn't know they were operating with a permit that was no longer valid. So we typically don't issue warrants, as I understand. Ms. Lamb can clarify more so here as the former prosecutor of a lot of these cases. But I believe we do not issue warrants and take people to court for their violations of operating after that termination of the permit by law. However, if after the issuance of a denial of renewal letter or a cancellation letter or whatever notice comes from our office, there's continued operation, that would give rise to a warrant. However, if on March the 1st of 2017, the former permit holder had come in, found out that they were denied at that time, made a new application, they would be held responsible for what they had done since the date that they found out that they had operated.
But in this case, they weren't denied because it was not noted that they had it was missed somehow that the property had transferred.
That's right.
Which is, I mean, and I understand the issue. I mean, it was the same owner that had it when they had applied before. They just didn't know that it had gone through another entity before it had come back to the original owner.
And I just wanted to distinguish that between these other cases you've heard where someone puts it in a trust and then they get caught and they transfer it back out. This is totally different than that. This is, someone did it for 8 days and went right back in. It's not, they then found out the law and then did something to try to pull the wool over your eyes or anything like that. This is just, the intention was always to keep it in the LLC. It wasn't as though they were getting an advantage entity-wise as we would, except for the financing.
But it was transferred to for 8 days?
Yes. It was from the LLC into two individuals back into the LLC.
And I think you're right, Mr. Collins, about the cases that have come before. Of all of them, this is the most equitable because of the 8-day, but there was still a transfer. And our job in this case is not to do equity, it's to determine whether the zoning administrator erred as a matter of law. And I understand it, and it is, you have a lot of equity on your side, and this is different from some of the other cases, but the property was transferred. And it doesn't really matter whether it was transferred for 8 hours or 8 days or 8 years. It's the transfer that's really the touchstone of this state.
But it doesn't have to be if then they were given the new permit. They weren't denied a new permit.
Well, and I understand that, but that goes back to but yet the law still changed. Even though I understand your client wasn't aware of it or they wouldn't have done this, obviously, it was still out there and it had changed. And we're also, as a board, bound to recognize that law and when it was enacted and when it changed. And
But to follow your argument, and I think this is what Mr. Taylor's asking, if they had gotten that permit, the law that was in effect when they, how I'm phrasing it, granted the new permit in 17, right?
Right.
And they're given that permit. Now there has been no transfer since that time, and all of those state law implications can come right back in.
Well, there's been no transfer since 2016, right?
That's right.
I mean, there was a transfer in 2016, and then you reapplied for the permit in 2017, right? But there's still a transfer in 2016.
But the permit then stated it was for 365 days, and then they get a new permit in 2017.
Okay, well, I don't understand what the 300.
It's a new permit.
Okay.
And there has been no transfer since that new permit.
Right, but you still have the transfer.
All right, is there any other questions or line of thought? This is one of the more complicated cases we've had, and so I want to make sure that we get all the arguments in and all the comments and the comments from staff and from council. So we've been very much free in letting the conversation flow, but I want to make sure that everybody has a chance to ask questions, but also if there are no more questions, then we can get to discussion.
I have one. A lot has been discussed, and I'm probably looking at very simply, but so what Metro Codes is enforcing is P of 6.28.030, and that's A, STRP permit shall not be transferred or assigned to another individual, person, entity, or address, nor shall the permit authorize any person other than the person named therein to operate a STRP on the property. Is that correct?
That's right, and you're also looking in conjunction, there are two different provisions regarding ownership in 951 and actually every short-term iteration of the short-term rental law that has existed since that time. Under C in 951, it says, no person or entity shall operate a short-term rental or advertise a residential property for use as a short-term rental without the owner of the property first having obtained a short-term rental permit. So if you read those two provisions in conjunction, you see the owner obtained a permit, then upon the transfer of that ownership, the new owner would have had to have obtained a permit, and that did not happen in this case. It was transferred back into the original owner, but that effectively killed the permit, and they would have had to come in to apply for a new permit before they could operate.
Well, the way I read it, I look at it, which is probably different. I have a different background than probably most people in this room. So I look at it as the problem is when it was transferred for those 8 days, if they didn't have a permit and they operated during that time, then that's really the problem. because they were still the same entity when they applied again for the permit in, I guess, 2017. So I have a totally different spin on that, but your light is on, I guess there's something else.
Oh, I like that interpretation. I'll go with that. But also, I think it's interesting that, and here's what I don't know either, based on Exhibit 5, which is the letter. I don't know what law, quite frankly, nor does my client have notice of, which section or which bill the zoning administrator is attempting to revoke underneath, because I think it lacks that specificity. I don't know if it's 951 or if it's 608 or if it's 492.
Yeah, but does that matter if it was lawful? I mean,
I think it does.
He didn't cite, I understand he didn't cite the specific
I mean,
code.
you have to have notice of what the violation is. That's required by R. But you also have to.
Not a violation.
Or
You're not on notice of a
cancellation.
violation because you didn't have any violations.
But at the same time, it then would give us knowledge as to what law we're applying here.
But
Because it did change.
each one of the ordinances has had the same requirements of no transfer of a permit, and any owner of a property must obtain a permit before operating a short-term rental. So regardless, by all means, take your pick. 951, 909, 492, 381, 608, state law, none of those change the fact that a permit's required before operation, permit for the owner, no transfer of the permit.
Except for 17-16-250E, if applying 251, only said it was an accessory use, and then it must apply 6-28-030, which has now been a repealed ordinance. So it would mean you're applying a law that no longer exists if it's the 250 under 951.
Are you aware of any iteration? I shouldn't ask questions. I'm not a board member. I would contend that there is no iteration of the law regarding short-term rentals here at the local level that has ever allowed a permit based on the zoning administrator and zoning division's application of the law to continue to exist after a change of ownership. And that is a by operation of law function, not a determination of the zoning administrator, a choice as the term was used previously. So if that is merely a letter that comes out of notice, hey, heads up, your change of ownership constitutes a termination of your permit effective on the date of that change of ownership, feel free to come in and apply again. Any iteration of that law which yields that same outcome nearly moots any reference to law that might be made, or if any section of law would have to be cited in a letter potentially, since it's not a notice letter of a revocation, I hereby take away, but merely a notice of, oh, here, by the way, you took it away yourself quite some time ago. We're just giving you that heads up.
And I understand the question, but I would submit to you, I don't know whether this is
Clearly not a question, because I'm not a board member. Just a discussion.
revocation or a cancellation, whereas a cancellation is nowhere in the statutes for short-term rentals defined. The only things that are defined are denials and revocations. So if it's effectively a revocation, which we would submit it was either it was a revocation and they weren't given proper notice, or it was a denial of the permit at the time where they were given the permit in 17. Or it's now a denial of the permit they got in 17, which then that 492 would apply. But no, I don't know of any situation.
Any other questions from the board?
Thank you, Mr. Collins, for coming back. And
no problem.
Anything else?
Your vigorous and thoughtful arguments on behalf of your client.
All right, we will close the public hearing and remind ourselves that it's an item A appeal challenging the zoning administrator's denial of a permit, and we can determine that the zoning administrator erred or did not err in this denial. And that's what we're here to do. And as I said earlier, it is one of the more complicated cases that we've heard, and I appreciate our newest board member digging into the packet as deeply as you did to help clarify some of that, because some of us that have been here a while have had 4 laws to deal with, and you got your lesson on all 4, I think,
I feel like I've just taken a law school.
in 1 week.
I feel like I've taken a law school exam. Probably Mr. Collins does too.
It's,
and Cynthia probably too.
It is tough to keep up with, and I know everybody, including the staff, wants to do the right thing by the current law and whatever law is applicable at the time. So what are the thoughts on this?
I would have to say that I think I very much appreciate Mr. Collins' efforts and his argument and his knowledge of the law. I equally appreciate Mr. Michael's great analysis. It's all very helpful to all of us. But I tend to think that Mr. Pepper is correct as to the application of the law in this case. I think John Michael has given us, there are a lot of different things we could look at here, but on the face of the law, while there may be questions that we don't know the answer to, I think the law, as we would have to apply it, would have us find that the zoning administrator did not err. That's just my opinion. I agree.
Yeah, and I do think that, the short period of time, there is equity issues, which I think we've all talked about and recognize. I do think that the point of June of 16, when that happened, is not as relevant as if there is any equity issues of what would have happened in March of 17. I think that's the only time the code staff would have had any reason to take a look at that. And if there was the mistake of not recognizing the transfer would have happened in March of 17. But I think that it's a fair statement to say that the zoning administrator didn't err, even though the quick pace and the way it happened is unfortunate very much for the applicant. So is there a motion for?
Well, I don't have a motion, but I bet the legislative intent was that when someone sells their property, that the permit will cease to exist, but they didn't sell their property. And I think that is probably the legislative intent of that. And this just doesn't seem to apply to that. But I'm not a council person, and a council person can come here and correct me, and that would be fine. But I'm guessing that wasn't the legislative intent. Someone else might have a motion.
I make a motion that we find the zoning administrator did not err.
Second.
We have a motion. We have a proper second. Any discussion? All in favor of the motion, say aye. Raise your hand.
Aye.
Opposed? It passes 4-1.
The last case on today's docket is case number 2018-696 involving property at 916 South 14th Street. Here's an aerial photograph showing you the property as well as the surrounding areas. This appeal is challenging the denial of a permit due to operation without a permit. Is there anyone here in opposition to this case? All right, that being the case, Mr. McBroom is here. He will have the presentation on behalf of staff. And you, the appellant, you'll have 5 minutes to make your presentation after Mr. McBroom speaks.
In my examination of this case, I found that it was actually an expired permit that they were advertising and operating on. The owner-occupied permit was issued on 26th of June in 17. Permit expired on June the 26th of 18. Host cease and desist letter was sent on July the 4th of 18. Estimated arrival of the host letter was the 12th of July in 18. There was only one documented stay in July and no further documented stays after that time. On or before September the 11th of 18, the website advertisement was removed, and on October the 24th of 18, the BZA appeal was filed. There were no documented complaints associated with this property, and no other action was taken by Metro.
All right, if you would, state your name and tell us what happened.
Evan Peary, 916 South 14th Street, Nashville, 37206. To be perfectly honest, I travel a lot for a living, and I was away from town during the expiration period, and I just let the permit lapse. I did have some communication with the zoning board. They told me I could come back in and reapply when I returned, which wasn't until September of this year. And then there was a red flag on the account, so I did what I was asked to. I know that, as was just stated, I pulled everything from Airbnb as I was instructed. I've been trying to abide by all your rules. I know they're rapidly changing, like we just heard in that last one. I hope this is less stressful. That seemed very stressful. Since the start, I've just been trying to abide by all the rules and was just trying to reapply and keep everything in good standing order. And I was just told I could come appeal this and hopefully get a chance to reapply for a permit this year. It's pretty cut and dry. I missed my reissue of a permit, and then I missed the 30-day grace period because I was traveling as well. And I'm just hoping to get a chance to reapply this year sooner than 1 year from that point.
Are there any questions for the applicant? I'll note that your council person, Brett Withers, did email a letter of support saying that he's inclined to support the appeal and request that the permit be issued or reissued promptly, which I know is as seriously as Councilman Withers takes these short-term rental cases, that speaks very highly of you. So.
I listened to what you guys instructed and reached out to my council member. So again, trying to do this by the book, missed my date, and that's not normally me, and I'm just here to hopefully get a chance to be on the books again correctly.
Any other questions for the applicant? If not, we'll close the public hearing. I will, did you want to?
Well, I was going to give you a break for making motions.
Please.
Thought maybe I would try to make one today that would pass. I will move that the zoning administrator did not err and that the applicant did operate on an expired permit, and that we assess a 3-month penalty, and that the applicant be able to apply again on January 24th, 2019.
I'll second.
There's a motion and a second. I mean, I would, because it has not been rented since June, I mean, I'm happy with Monday, but.
How about January 15th?
No, I mean, that's, I mean, if you have a motion and a second, we can take it. Like I said, I think, you're just having bad luck today.
I wanted to do something that works, but that's okay. If you all want Monday, Monday's okay.
I think we had a motion in a second.
Yeah. If you wanted, there is a motion, there is a second, but you had said you would amend your motion to the 15th. If there's a second, then we can have
And I will approve that amendment. I'm the second, so I can.
I'm perfectly happy with that, by the way, so I'm good with the 15th. Thank you, guys. I appreciate it.
What is the motion?
To apply on January 15th.
There's a motion on the 15th. There's a second. All in favor of this applicant being eligible to apply on January 15th, say aye. Aye. Any opposed? You may apply on January 15th, and you won't have a permit till you get a permit, but you can reapply on the 15th.
Thank you all so much.
We're adjourned.
Gosh, it's not even dark out. Oh.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.